That's not how it works.
It's just not a man.
What the fuck? Hold on. What the fuck? Making 6 figures a year, 7 figures a year, bringing breakfast to a fucking woman. That's your fucking job. I'm not doing that shit.
Why isn't my job? No offense, that's kind of
I have to take care
of you. Hire somebody.
That's your fucking job.
No, it's not.
Because I'll tell you this, if someone breaks into the house, you ain't gonna fucking say, oh, I'll go fight them. No, I gotta go do it. I think, yo, can you stop like ad-libbing, bro? As I'm talking, it's so annoying. Stop. Yo, anyway, come over here, bro. Crazy. So the point is that as a man, it's your job to do certain things. As a woman, it's your job to do certain things. I find it ridiculous that women want us to do their job sometimes. Like, no, bro, I'm not doing it.
No, it's a treat.
A treat?
Yeah, like, we're gonna do it the other day.
Unless you're dying, nigga, I bring you shit, nigga. Like, that's crazy, bro. Come on, man.
No, that's you, though. You're not a sweet romantic.
I am, actually. I'm so nice.
You're not romantic.
The guy that's gonna bring you that breakfast in bed, I'll tell you right now, you're not gonna like him like that. You're not gonna be attracted to him like that. That's gonna be the guy that you guys friend zone. That's gonna be the guy that, he's nice and all, but I don't feel it. I'm telling you guys. The nigga that will bring you breakfast in bed, you don't like him like that.
Listen, I'm a dookie in that breakfast.
Occasionally, it's nice for a relationship is two people who love each other, who are best friends, and who want to do nice things for each other. So there is absolutely nothing wrong with the man.
That's another fallacy. Best friends in a relationship, it doesn't work that way.
It's a partnership.
Oh,
you're saying a marriage is not a partnership? You're signing a marriage contract.
So let me get this
a
straight.
partnership.
What is marriage to you? Did you not say earlier that you have high standards, you want a guy that's better than you?
Yes,
I did. So how's it a partnership?
When you enter into a marriage contract, you're actually entering into a contract between two people. A contract between two people, by default, is called a contract. It's a partnership.
Okay, so yeah, but how's it a partnership when he's bringing more to the table than you are?
It shouldn't. He's not bringing more than to the table.
No, by definition, he's bringing more. You have higher standards.
But you guys are bringing stuff together.
More in maybe emotionally, lovingly, doing more
That's emotion. All of a sudden, my brain hurts.
There's different values. There's different tangible or intangible values.
The next one.
See, here's the thing. Partnership assumes equality. The guy's not equal to you. He's better than you. So I don't think it's a partnership whatsoever.
Okay, I don't. He's better than us. You're better than women. Conversation.
Are you retarded? Are you listening to what she said?
I don't care.
She said earlier, that's the problem. You're not listening. You're just yapping.
Because y'all are going in circles. Why am I going to keep listening to something?
Okay, yo. Look, she said she wants a guy that's better than her. So I'm going off of what she said. Don't just fucking comment a bunch of dumb shit like,
I've been saying that. I mean, like, who gives a fuck at this point? Y'all both have y'all separate opinions. Y'all are not going to agree. This is like, y'all are the only ones at the table.
All right, man, just be quiet, bro. Just be quiet. You're not contributing anything. You're just lowering the IQ of the conversation. I'm just saying,
nobody else is contributing but y'all.
You're not contributing nothing.
Y'all two at the table are the only ones speaking.
You're lowering the IQ of the conversation. You don't even know what the hell we're talking about. You're just yapping. I don't like it, no bar. Stop.
Right,
You've not contributed anything logically sound that makes sense whatsoever. Just stupid ass ad-libs with your country accent, 50 IQ.
I haven't even been speaking, nigga.
You have, and you said a bunch of stupid shit.
All I said to you was, you're going in circles. I agreed with you like 3-5 times. I don't know what the hell you're talking about.
Yeah, but you still not listening to what the fuck's going on.
But that last time was nonsensical.
Yeah, you're just yapping before. We're in before.
You never crossed the line. You only snorted. Let's fucking go. We have a delusional feminist on the panel.
You're losing more.
I am, thanks to you.
Because of you.
Yeah, because of you.
No, I think you've been balding for a while.
I've been losing stiffness ever since you started talking. This is true. I have been balding for a while because of morons like yourself. Sure, it's been tough. But we got a girl here that rates herself a 10 out of 10, as if she's perfect.
Yeah, I don't know. I knew you were going to say that too. I looked at one eyelashes and I just knew it. It's always the correlation with the eyelashes and the level of delusion in your brain is that mathematical equation.
I
should
feel
be
like
cited
I'm a
in
10
books.
because without makeup, without lashes, I'm still pretty. Like.
So take them off. Wash your face, take off the wig and the lashes right now. You're still going to call yourself a 10?
I'm not about to do that right now.
Okay, so you're not a 10, and you don't
I
believe
am
it.
a 10.
What do you mean take it? This is not Halloween, bro. No one's taking off their makeup. The fuck? This is a horror show. This is a dating show.
If you really believed you were a 10, you wouldn't walk in with makeup and lashes and a hat hair.
At least
And a
20
hat hair.
Yeah, that's a whole
And a hat hair. hair
Yeah.
and a hat hair.
Bro, your facial hair literally looks like boobs.
Literally. What?
Okay, thank you. The second time that you're gonna go play.
Like-
Hey, remember the title of the video? Low value women attack high value men. Okay, be honest
How
about
are you high value when you talk to women the way
it.
that
Here's how I'm high value. You're a woman, and I get more DMs from the opposite gender than you. I get more DMs. I get more girls who
You're
text me,
probably gonna
and
get
you have a
STD and
hole.
fucking die alone because you don't respect women.
If I got
That's what is
if-
gonna happen.
No, he really
And you're probably
be
gonna
with
lose
men.
If I'm gonna be honest, no, she's right. If I
Get fucking married, so.
she's the cat woman is right. If I got an STD, I'd be like, damn, now we're even.
You probably already had.
I've never had an STD. Okay, no,
Don't lie.
Please,
Don't even lie right now.
please.
no, I fuck teenagers. They don't have STDs.
Yeah, so that
Bro,
was.
you should be in jail. That's like.
No, they're 18, 19. 18
That's
on
so
the
fucking
birthday.
nasty. That is so nasty. You should have.
Call the cops, bitch.
That is fucking embarrassing. And you're a high value man.
FBI, you're solid.
You're a high value man saying you fuck teenagers. You're a disgrace.
Well, the teenagers both be 18.
I
Yeah.
thought you fucked
younger women because they're less.
No, they're hard to catch. They got rollerblades.
Bro, because you need to get with people who are easier to manipulate.
No, you bitches are.
Of your fucking brain.
You look like the.
You can't get.
She looks like the fucking. She looks like the mummy from the movie The Mummy. I want the young bitch. I want to talk about anime with the young bitch. I want to watch Inuyasha and Dragon Ball. I want to talk to these fucking. Imagine fucking this girl and Sam is pouring out her pussy. What the fuck? Yeah, bro. I want 18, 19 DM me.
You're proof that we should get girls who are 18, 19. Because if
I'll take you to the playground, girl. Let's get some ice cream. Let's go.
18, 19, and y'all almost like 38. That's
I'm 42.
You're 44?
42. I still got time.
You look like you about 30.
Okay, thank you. And it's proof that I think we should actually, this is proof that 18-year-olds are
You're
better
aging
because the
back.
older you get, the more delusional retard you get. It's not like you're on the same level.
Bro, look how you're fucking talking. You're gonna actually die alone. Like,
Am I?
yeah, like 100%.
Do you know how many girls I have in love with me?
Who gives a shit?
Okay, obviously, you clearly. And to get in your eye, I will say, look at the way you talk to women. You started the show saying men are trash, dummy. What are you talking about? You're a misinterest live, and then you're gonna be, oh my god, I'm a victim because you're degrading men, stupid.
Honestly, I can't pay attention to what you're saying because I just see the fucking class coming through your fucking teeth.
All right, the what coming from
Man,
the
you had too much money today. Come on. now.
Black.
Okay. Yeah, your roasts are terrible, man. Just stick
I
to
was hoping
modeling.
you'd come with something better. Like, make fun of her for being like half Asian or something.
Something.
Fuck girl would be like
You're not racist.
pale girl would be like necrophilia. She looks undead. She looks like a fucking zombie. Right?
It's also proof that you have nothing to offer besides beauty because it's definitely not your bubbly personality.
You
You
literally
got
look like
nothing.
a crack.
Hey, you gotta come meet Adam's family.
You're a crack.
You got nothing.
This girl looked like she got flies around her pussy, bro. She looked dirty.
Oh.
Yo, should we keep going? Are we allowed or is she gonna cry? Wow. Don't cry. Don't turn me on. Don't turn me on.
She opened the door by trying to roast first, man. That was a bad move.
Bro, the fucking cocaine is getting to your fucking brain.
I
I feel like it's weird that you get turned on by girls crying.
Now you made it personal. You attacked my coke. Look at me, bro. Never on me. Hey, you never crossed the line. You only snorted. Let's fucking go.
Hey, man, you open this door, you try to talk shit, and you get right down, man. Oh,
Honestly,
Lord.
I don't even care because everything that
You don't care. You're gonna jump off this balcony. I have to lock it, bitch. You're fucking done. You're low
I wish
HP.
that you would jump off this balcony, honestly, because the way that you're acting is insane.
Honestly, you're not just not hot. You're also retarded.
You are also, and you're a fucking man.
I know you are, but what am I?
You know what's funny? She's gonna go to a coffin tonight all alone.
You too.
I don't have a coffin. Look, I'm tanned. I'm olive. I'm Albanian. Let's fucking go act black.
Bro, your hair is like exceeding to your fucking back.
Yes, sir.
She reminds me of those women who don't shave the bush.
Bitch, have you seen your back? Hello?
I know, no. We all have that problem.
My back is sexy.
Hey, let me tell you something. Invest in lasers. That's what you gotta do. Invest. Okay?
I'm serious. You better stop spending so much time at the graveyard and laser off that pussy.
Look at you, you're full of hair. How do you keep going?
Keep going. I don't want to keep going. The only thing I like about her is the Sith Lord robe. She looks like so badass in that.
Listen, you guys literally have this blanket. It's a blanket.
Okay. Do you have tits?
No, I don't.
Oh, you are just a disaster. Holy shit. Shit. Okay.
Well, she opened that door, man.
You asked for it, so. See, I'm not gonna lie. This is why I went famous. Like, this is so unfair.
Keep going, keep going.
Is that it?
Wait, what did he say? What did he say?
I feel like I'm bullying you, right?
Not really. I genuinely, like, nothing that
Don't
you're
cut
saying.
yourself when you go home. Okay.
Let's just focus on you, bro.
Holy shit. Yo, I'm just worried. I'm worried she's gonna start floating.
Bro,
She's gonna start haunting me.
Please don't overdose on the fucking amount of coke that you do.
Album Breach and this chick are getting roasted, man.
Wait, no one's ever told you you look like a ghost?
Maybe you need to go to
Either you look like
need to go to rehab.
Either this bitch.
lie. You do got some power like that.
Hold on. I appreciate that. Right?
Bro,
Now
maybe
check
your
this out.
teeth are rotten.
I'm ashy.
Maybe that's why yesterday your teeth
Check this
fixed
out.
because your fucking teeth are rotting, bro.
Let it out, baby girl. Yo, check this out. Don't haunt me, right?
You are gonna
Don't
own
haunt me. And honestly, everything I said, I don't mean you're beautiful.
Nice.
No, I mean everything I said.
Yeah.
You know what's funny too? You look like him after he overdoses.
No, I actually I'm not gonna lie. I want to fuck her. I've never fucked a fentanyl addict.
How does that even make sense?
You look like an abortion that made it.
You look like an abortion that literally failed.
You're a success story.
He's a success story. He's a crack baby.
You look like a ghost looking for your soul.
Bitch, you look like a fucking...
You know what's funny? Here's the best part. I was an Armani model. Let's go in the chat.
Let me see your real teeth under that fucking...
No, they look like yours.
My teeth are perfect, bitch, and I've never had fucking braces. Don't fucking come for me.
You have good teeth?
What?
Okay, yeah. No, vampires have great teeth.
Yeah, fuck you, bitch. Vampiro.
Oh my goodness, bro. Okay, please give up now. Yo.
No, I can keep going. Keep going.
One of the biggest.
Rap battle, 50-0. 50-0, bro.
Holy shit.
A success story. No, honestly, you're cute. You look like all the girls in my DMs. Right now, they DM me nice things. Like, they all look like you.
Kobe Bryant, 8
When you get women...
The only difference is they're left on red. I'm talking to you.
Because for sure you go for minors.
Can anybody cares about your
Listen,
respect?
can we see your ex? Does he look like me?
Not at all.
Can we see one photo so we can laugh? Okay.
Are you even in a relationship?
Many. Right? I said I like teenagers, bro. I'm always at the playground. Fuck what are you talking about?
That's insane.
What? Bro. Hey, you're 18 and 19. We're good, bro. FBI and chat, we're good. It's either teenagers or the alternative, these women. Do the math, bitch.
You're making a good case for the teens.
Women's brains stop developing sooner than a man's. This means that a woman is set in her ways at a younger age. Men's brains continue to develop and adapt into an older age. They are more mature and experienced at the point of development. Girl by Myron is 30. That's I think in response to the other girl. B-Brain 304s. Fair enough. Steve says, if someone dropped the gangster boss babe act, she'd be white. Fine as fuck, feminine vibes, and she's actually really talented. Plus, airhead chicks are hot. Anyone else?
She has a kid. She's not
I
white.
think you're on your own on that one.
Yeah, bro.
Don't be a simp. What else do we have here? This Gruzzle Care goes, if you don't care what men want, this is for you. Why would you be on a men's podcast talking about high-value men in the first place? Seems like, to me, that you were just trying to get attention from the male ego to justify your stupid decisions in life. You have a response to it?
Not really.
Fantastic. Myron looked like a proud dad when fresh either dad. We're on YouTube, my friend. I can't say American Income, W Fresh Castle, shout out to CEO Network, shout out to American Income. If you guys want to level up in life and have access to the best network, join the network, best money I've ever spent.
Shout out to you, bro.
And then what else we got here?
I was really proud when I saw you do that castle. I was like, that's my guy, Fresh. Yeah.
Be honest though,
She needs to roll out, bro.
Yeah, she needed to go. Yeah, that was brutal.
That's
we waited an hour, bro.
It's crazy.
2 hours.
Where we at here? Anything you put on the internet will always be there, even if you delete your OnlyFans account. Someone has always downloaded your stuff and posted somewhere else. Don't think that your stuff is only on OS and not on random guys' phones.
I'm aware.
All right, fair enough. The fact that the girl next to Myra said that she doesn't care about a man's opinion proves that women lack empathy. No mames, FNF, and the rest of the RP panel.
The empath shit is all wrong.
Yeah, I've argued that women are less empathetic.
You're not empathetic, you just cry more.
Yeah, women are more sympathetic, but they're not more empathetic. Big difference. Where we at here? Rams, a woman who sells her most prized part for sexuality is like a car that drives out of the dealership and immediately loses 50% of its value. You have anything you want to say back to that?
I'm okay.
Okay, fantastic.
1750.
Circa search if anal and reach were dishonorably discharged from Canadian Forces Military for insubordination.
Holy shit!
Were they?
Yeah, I come from that same military family. I'm a KO you both when I see you in person in a video game. Minecraft.
I'm gonna preach.
I dare you to talk in person. Lie in person, you little fucking cunt bitch.
I know you're
I'm fucking KO you with a GoPro on my head. I'll knock your bitch ass out. You look like a fucking retard. But we're kidding. No
I want them
violence.
to respond live, but they will not. They're gonna jump cut everything to hide Preach's retarded.
They come to Miami. You guys come to Miami so often. We will cross paths. I promise.
I guarantee you they're gonna make 10 more videos of how like they're winning and stuff, but they're not.
They're not. You guys have been exposed as being frauds. Okay, where we at here? Happy birthday, Big Mo. Gems in every show, fellas. You're killing it. Why do you lie so easily? Okay, I see what you did there. And where we at here? How many more, Chris? Okay, yeah, 3 more, because the guys were reading the ones up from before. The fact that the girl next to Myra said she doesn't care what men think demonstrates that women don't have empathy.
You read that?
No, mama. Yeah, we read that. Shout out to you anyway. Myron, Sneeko, Zerka, and Fresh are the winners. The 304s are dumb as hell. They lost. Damn, holy shit. Still a great night, though, to everyone. Okay, appreciate that. And then Tubsy goes, Zerka, I'm stacking DMP and meth.
Whoa. Pause. My overdose I had when I used to be a fitness model was with that drug. The ingredients are rat poison and dynamite. And I cooked myself into a fucking coma, and I overdosed twice, and I mixed it with like 4,000 milligrams of other compounds. That drug will kill you. Make no mistake about it. And it's catabolic. You're not going to look lean. You're going to be stringy. It's not a good cutter. Honestly, all the fat burners are bad. That's the most dangerous drug in all performance enhancement or stimulants. And
just go to the gym.
Don't do that drug. That drug will kill you. Look at the statistics of how many people cook themselves alive with that drug. Their organs were at a temperature so high they cooked themselves. And I went through it. Don't touch DMP.
The funny part is he's sweating. He said he's sweating like a dog in a Chinese restaurant. Yo, what the fuck, bro?
You want to lose weight? Do some blow.
Oh, man. Darnell Elliott.
Adderall. Wait. If you're obsessed with drugs, like you have to do with drugs, Adderall wipes out appetite. It's an amphetamine, so it gets you very active, and you actually schedule your food better and stuff like that. And the dopamine allows. It's like if you're gonna cheat, use Adderall. Go to your doctor and ask for Adderall.
Okay, here we go. Darnell Elliott, Mr. Gaines, for the love of God, will you please stop telling your listeners to do FHA loans? Pull a mortgage calculator up, and you will see you are wrong. Your house will cost about 3 times as much. 20% down, 15 years, the way to go. You know I'm correct. Bro, Darnell, I have 13 real estate properties, my friend, okay, in Florida and Connecticut, okay? I know more about investing in this shit than you. For someone that doesn't have capital, the best way to get into real estate is get an FHA loan to control the property. You can always refinance or put more money down the road, but the goal is to control assets, my friend, and the easiest way to do so is through an FHA loan. Stop being a moron.
No, you know my dad said that? He's rich. I'll bet you anything he's rich. That's why he's saying
crap, dude. Like, yes, they are going to pay more over time, but the goal is to get the asset, and then you can go ahead and refinance after the fact, but control the asset, my friend.
Yeah, that's privilege.
You can't start off with that amount of money, bro. No one has that.
Most people are not going to have $100,000 to put 20 to 25% down. If you have that money, do it. I tell you all the time. What is a little down as you can get away with. If you have 25%, go ahead and do it. But the average person doesn't have $100,000 to put into real estate property.
They don't.
Darnell, you gotta get it. Come on, bro. Come on. Stop being low IQ, man. You were giving advice to the majority of people that don't have that kind of capital, man. Shit, you're doing the same thing that this girl in the corner is doing. Putting it back to yourself is the exception. Black Stallion, $50. I appreciate what y'all doing. I'm 23 in the IBEW while also a TRW mastering the stock course. I've been in for 5 months and made thousands already. FNF, Sneeko, Tate, and Zerka are guys. Let's go. See my friend. All right, the real world is what it is. Sorry. Men build and frame the world we live in. Women populate and give us a world to live in. Let's not sit here and act like the one outcompetes the other on every scale. Also, the chat is almost as brain dead as the Coke Zerka.
Don't do drugs, guys. Don't do cocaine.
You know, it's a joke, guys. I take prescription Adderall. Like, it's a marketing gimmick so people think I'm going to destroy my life. But you're going to keep tuning in. You're going to see I didn't stab someone. I didn't.
Hey, bro, don't tell them the secrets, man.
You're right. You're right. There's too many viewers.
Okay, ladies on the panel, this is your time now to shine. Give us questions, statement.
Imagine.
Question statement, or for example, your last thoughts on the show. We'll start right here.
I mean, I guess it was fun. I like giving my opinion and debating, so.
We took Ellen. Are you gonna change your ways?
I don't know. We'll see.
Thousand cabs.
Absolutely not. What about you?
I think it was fun, and I think you shouldn't take anything personal.
Right.
Easy for you to say you're laughing at all the girls. Easy for you to say you look like these bitches are stupid.
I forgot she's even here.
I was looking at her, she was laughing the whole time at the chick, man. Okay, but
Look, she turned 37.
No, that is
He turned 37.
all right, go ahead. You got anything else you want to add? Disagreements? Whatever? Oh, for you. No, this is you. Anything else? That's it? Okay. I know you got a lot to say. Go ahead, take it away. This is your time.
No, I think women are just disappointed in,
You look like a Scooby-Doo
men
character.
that.
You're gonna take the mask off and be like, I would have gotten away with it.
You red cell kiss.
It's like a let her finish.
Okay, I'm finishing her off.
Let her finish.
Desert Storm. Yeah, Scooby-Dooby-Doo. Where are you? And it's funny because she be chasing guys and the guys be running into doors and shit.
Alright.
Yeah, she more like Scooby.
Alright, go ahead. So you said you were disappointed or something like that. Come on, man. Come on.
No, I do understand that people need to do what they need to do to like be successful, whatever it is that they need to do.
No, Toma's right.
What do you think it is that we need to do to be successful?
I don't know. I just like I feel like praying for you guys. Like I
Praying the mystery bag, bitch.
genuinely like I'm like observing and just listening to you guys and
Okay, let me ask you a question. Would it be fair to say that you have to bear a little bit of personal responsibility for the treatment that you receive?
what do you mean?
Wouldn't it be fair to say that you have to bear a little bit of responsibility for the treatment that you've received tonight?
I don't think I deserve to be disrespected. No, I don't think anyone deserves to be
Who was
disrespected.
disrespectful first?
You attacked Nico, didn't you?
You said men are trash before we
Would
said
it be fair to
anything.
say that you were disrespectful first?
You scared him. You're like,
Even then, I don't take that out. Take that out. Okay, so do you believe
Hold on,
that
don't deflect because you've been doing that all night. Were you disrespectful first? Yes or no?
if you take meowing as disrespectful, then yes. But I
And
personally
shut the
don't.
fuck up, too. And the shut the fuck up part. And the men are trash.
You guys have been disrespectful all the time.
Or were you not disrespectful first? Yes or no?
For the shut the fuck up, maybe, but not for anything else.
Okay, so you're not going to take accountability for those things. Fantastic, that's fine.
and the meowing was a lie. It should have been oink oink.
And yours should have been sniff sniff, but anyway.
Yeah, it is.
My point is this, is that the thing is that women don't like when men reciprocate. What I mean by reciprocate is if you behave a certain way, sometimes there's consequences. Not every guy is going to tolerate disrespect from a woman. Some guys
He was
might.
disrespecting first.
What did I say?
He
No,
was
I
going crazy
wasn't.
since the beginning.
No, I said you're lovely. No, I was lying. I said you're lovely and cute.
You were telling people to shut the fuck up the whole entire time.
She didn't do
And
that.
you were gonna fuck them since the beginning. It's been disrespectful.
Honestly, without me, you guys won't have views.
Wait, well.
Leslie Beasy and Zach Wichow.
Good afternoon. Attorney Michael Comey appears. Mr. Brooks appears in custody via Zoom.
Mr. Brooks, can you see and hear the court? He's giving me a thumbs up. Are you able to also see your attorney through the Zoom?
What was that?
Are you also able to see your attorney on Zoom? All right, and that's a yes, sir?
Yes.
Can you answer verbally, please?
Yeah.
Thank you so much. And any objection to appearing remotely today, sir?
No.
And has the state complied with victim rights?
Yes.
As everyone is aware, the court is live streaming through the Daycast function of Zoom that CCAP has made available for circuit courts in Wisconsin, and we've been able to verify it is up and running. If at any point in time anyone gets word that it is not, please let me know. We are here today to address a motion to withdraw that was filed by Attorney Covey. I do want to ask you a number of questions. The first question is it your understanding that Mr. Brooks would still like you to pursue this motion?
Yes, Judge.
All right. And Mr. Brooks, could you also confirm that for me, that you are seeking Attorney Covey to be relieved as your criminal record for your appeal?
Yes.
For purposes of today's hearing, District Attorney Basie, do you agree, or is there any dispute that Mr. Brooks is indigent?
I have no information to say otherwise.
All right. And do you have any dispute that we are concerned with Mr. Brooks's direct appeal rights at this point?
No.
All right. Do you agree with those two issues, Attorney Covey?
Yes, Judge.
All right.
He's absolutely indigent.
He's in custody. He's serving consecutive life sentences. He's indigent, and initially, even when he was the accused, was eligible for public defender representation. And do you have any information, Attorney Covey, that would suggest otherwise?
No, Judge.
All right, thank you. So let me start with some questions. What I intend to do is I want to make a record of a number of things related to the inquiry that this court must make under the law. I think it's important to start with directing the questions to counsel, because as of right now, you do represent Mr. Brooks, and then I intend to address some questions to Mr. Brooks as well. Attorney Covey, have you received and have you reviewed the February 26, 2025 letter from the State Public Defender's Office?
Yes, I have.
Were you aware or have any knowledge of whether that letter was received by Mr. Brooks?
It's my belief that it was sent to Mr. Brooks and that he has received it. I haven't confirmed that with him personally, though.
All right, I intend to do that in short order. Is it true, Attorney Covey, that you were appointed for the purposes of investigating and pursuing potentially an appeal for Mr. Brooks on January 6th of 2023?
Yes, Judge. I was appointed for post-conviction and or appellate relief.
Thank you. And what have you reviewed in your work on this case thus far?
Judge, I have spent probably hundreds of hours. I know this past summer, the vast majority of the summer, my free time was spent reviewing this case, including all of the transcripts, the entire court record, the vast majority of the discovery. I'll make a record of that. There's certainly, when we get provided with lots of audio and video evidence, not all of it is directly relevant to the offense. If, for example, if there's a squad video that's just pointing against the wall, I'm not going to spend hours reviewing that. But the key evidence, the interviews, the court exhibits, I definitely reviewed all of that discovery as well. We have about 5 banker's boxes of materials that I have gone through, including the prior attorney's notes before Mr. Brooks went pro se.
Have you met with Mr. Brooks either in person, by phone, or in any other way?
Judge, I have, and of course I can't talk about the substance of that, but I have met with them in person several times, plus numerous phone conferences as well. I haven't counted, but a large number of contacts.
Have you had written communication with him as well?
Judge, I'll write him letters. Mr. Brooks and I would generally communicate via the telephone, mostly telephone and in person.
Have you sought a number of extensions from the Court of Appeals related to the timing of filing any post-conviction motion or direct appeal?
Judge, I have basically two groups of extensions, if I may explain. The file is huge, and so it definitely took me longer than normal to review the contents of this case. And so the first few extensions were just to get me through the summertime where I was able to review all those bankers' boxes of materials. The second set of extensions were filed so that Mr. Brooks, after him and I had fully consulted each other, would have time to decide how to proceed. I know one of my more recent extensions was to give Mr. Brooks the opportunity to try to hire a different attorney if his family was able to do so. That's part of the public record, of course. So those are the two groups of extensions that I filed over the course of the last year and a half.
Do you know how many?
The most recent extension was the summoned motion to extend time. That was to give, I'm sorry, my apologies.
The record shows that on
I think there was
February 14th, the 8th motion to extend was filed with the Court of Appeals. Would that seem accurate?
Yeah, I misspoke. It's the 8th motion to give Mr. Brooks time to litigate his case. In the event that I withdraw, he'd have a couple of extra months to review the file and to do his own research.
Again, I understand that you can't discuss confidential communications with Mr. Brooks as his attorney, but generally speaking, have you identified issues to pursue on appeal?
Judge, I can say this. There were several very specific issues that I spent an enormous amount of time researching for appeal as to whether or not they were viable post-conviction or appellate issues. I'm not able to say without breaking privilege.
Have you sent Mr. Brooks any drafts of pleadings related to any appellate or post-conviction issues?
Judge, since I haven't filed an actual appellate brief, we haven't done the notice of intent to appeal, nor an actual post-conviction motion, there wouldn't be any pleadings for me to send him. So we're at the point, if I may, give a little bit more elaboration. Usually it's a two-step process for post-conviction relief. The first part's actually the longest. It's assembling the court materials. I know the court reporter worked exceptionally hard to get me those materials, but that took a few months. Going through those materials, identifying issues that could provide post-conviction relief. In some instances, there are no grounds for post-conviction relief, and then there's a different set of options that I would go through with time. So after going through all of those steps, I did have multiple contacts with Mr. Brooks, both in person and over the telephone, for him to decide how he wants to proceed. I'm not able, even if hypothetically I found 5 amazing grounds for post-conviction relief or appeal, I wouldn't be able to submit any post-conviction motion or notice of appeal without the consent of Mr. Brooks. If I found no grounds for post-conviction relief, then again, Mr. Brooks would have a set of options that I would have to go over with him. And I can say that we have gone through that process, and he has requested to proceed pro se, which would prohibit me from filing any further pleadings in this matter. I hope that clarifies the issue.
Well, it helps because my responsibilities ultimately when discussing with Mr. Brooks is to talk about the options. One option could be a no merit situation. So I generally just want to know if all options have been discussed with him at this point.
Absolutely, Judge. That I can say 100% certainty. And multiple times.
Is it your understanding that Mr. Brooks wants to proceed pro se or on his own, or as he sometimes referred to it as in pro per person, I think was the phrase he used with some frequency.
Judge, he does want to represent himself moving forward.
Have you discussed with Mr. Brooks your background as an attorney in doing appellate work?
Judge, I don't, it's such a, it's a innocuous question. There's no issue with me answering it, but I'm afraid that if I were to go into any discussions.
Let me ask it this way.
Yeah.
So I would like Mr. Brooks, and I'd like, actually, let me state it this way. I would like the record to reflect your experience for purposes of my decision here today. So I'll just ask you some general questions. They would not in any way violate any type of attorney-client privilege. First of all, are you a licensed attorney in the state of Wisconsin?
I hope so. I also in a lot of trouble today. Yes, ma'am.
How long have you been so licensed?
Approximately 20 years, actually 22 years, I believe.
Do you hold licenses in any other states or have permission to appear in any other courts outside the circuit courts, appellate courts, and Supreme Court in the state of Wisconsin?
Judge, I did take and pass the Illinois State Bar, and I was part of that community for a few years. I let that lapse because I have solely practiced in Wisconsin.
What about federal courts?
Judge, I was trained to do some federal courts, and I was actually accepted to be an attorney in the Western District. Then COVID struck, and the caseload for the states became so extreme for lack of public defender appointments that I never ended up practicing in federal court.
Do you have any area that you focus on in your practice?
Judge, I focus mostly on homicides and sexual assaults, if I may. The State Public Defender's Office, let me backtrack. I'm not a public defender. I'm a full-time criminal defense attorney. For most of the last 20 years, I had my own practice. Recently, I joined Corey Chirafisi for his law firm, CHIRAFISI. For most of the last 10 years or so, I have been practicing mostly homicides, class A, B, and C felonies.
Give me 1 second. Mr.
Sure.
Brooks, would you please direct the camera up? Thank you so much. I appreciate that.
Judge, the State Public Defender's Office has certifications to take certain levels of felonies. The highest level of certification is Class A felony, and I'm certified to do those in both the appellate and the trial court level. Approximately 20% of my work is with appellate work. I'm in trial more often as with the circuit courts.
In your litigation practice, both in the circuit courts and appellate courts, that's both through appointments and individuals who would privately retain you?
Absolutely. I have the highest level of certifications the Public Defender's Office can give.
Thank you. Have you had any general discussions with Mr. Brooks related to appellate rules and procedures, whether it be formatting, initial briefs, what response briefs are, the requirement for reply briefs, or even the difference between that and a post-conviction motion?
Judge, let me just say this again. I've certainly had lots of conversation with I've spent hours with Mr. Brooks in person and over the telephone. I'm going to speak in very, very general terms. The vast majority of those conversations have to do with the substance of the case itself, the issues that I was researching on this case, and there were some very specific issues which I'm declining to say now for privilege reasons, but that I was researching on this case, going over the case law, meeting with them to discuss lots of different issues. Certainly as part of that, I would have, with every one of my appellate clients, I would have conversations about basic appellate procedures, such as the difference between a post-conviction motion and going straight to the Court of Appeals and why that would occur. That is, as to the details of drafting a brief, rules of citation, the fonts and procedures that you have to do to submit an appellate brief, I, of course, have not had those types of conversations because it was my intent that if there was an appellate issue, I would be drafting that brief. I can say this, and I'm happy to do this, to allay the court's concerns. Certainly, it's my intention to send Mr. Brooks a copy of the rules of appellate procedure for Wisconsin. We'll make sure he gets that. Additionally, in my experience of doing this for a long time, that the Court of Appeals will still hold pro se defendants to the letter of the law and the substance of the case. They won't give the pro se defendants any breaks on the substance. If there is an issue with page numbers or citations for a handwritten brief that would be submitted by a prison facility, I've never seen an issue where the Court of Appeals has objected to that. They're a little bit more lenient on those issues for obvious reasons.
Thank you. That was I don't want to say a concern, but a question I had, and that's good to hear. So thank you. Is there anything else you want me to consider in light of the motion that you filed with the court?
Just that I'm not, even if I was allowed to withdraw it today, I'm not going to close the file until Mr. Brooks has the entire file. I was speaking with our paralegal staff just yesterday, going through multiple banker's boxes of materials. The facility where he's being kept at right now will not accept those materials. It's just too much for them to take in. However, if we scan them, download them, and put things on hard drives, multi-gigabyte hard drives, we can send those out. So it will be a very lengthy, time-consuming process for us to do so, but I'll make sure Mr. Brooks gets those materials with one caveat. Because of the time and expense to do that, we wouldn't be making multiple copies. So if something were to occur where Mr. Brooks would want another full set of materials, perhaps 8 months from now, it would be challenging for my firm to comply with that request.
So let me make sure I understand this. The prison facility at which Mr. Brooks is currently serving his sentences will not accept the volume of material that you have in paper, even standalone electronic, other than on an external hard drive.
If we sent them desk and flash drives, I'm very confident the prison would accept that. But they made it clear to our office, and it was their staff speaking with my staff, that they would not accept, if I were to ship 5 banker's boxes of materials, they would not accept that. But if we put those materials on computer electronics, then they would have a place where they could store it safely and easily, where Mr. Brooks could access it in their library.
It is not a secret that Mr. Brooks is no longer being held in Wisconsin. If he were in Wisconsin, would you have had better access to him in terms of going to the facility, even with your own computer, and as his attorney showing him discovery if need be?
So I was able to visit Mr. Brooks at the Dodge Correctional Institution, and additionally at the Wisconsin Secure Program facility in Boscoville. The prison facilities made it very easy for me to do the visits. I was able to bring my case files. I wouldn't have brought that volume of materials to a meeting anyways, had I desired to go through any piece of audio video evidence. There would have been a mechanism for me to do so in Wisconsin. If hypothetically, if I were to remain his attorney, I am able to have telephone and Zoom conversations with my clients. It would be a little bit more onerous for me to do in-person visits.
If you were able to do Zoom, you obviously can share screen, even information from your computer.
If that's what we wanted to do.
Do you know what, if any, materials Mr. Brooks was able to take with him from his trial to the facility where he is at?
Mr. Brooks might be able to answer this better than I will, but it's my understanding that somehow along the way, when he was transferred out of state, he no longer has those trial materials. So we would be working to give him a complete set of what we have. And that would also include downloading all the materials from the e-file and putting that on a separate flash drive as well.
But you're willing to do all of that?
Yes, we will get extra funding from the Public Defender's Office to get extra paralegal support to do that.
And they're willing to do that as part of the case closure should this motion be granted?
I have not put in that request yet, but I am certain they'd be willing to do it. They've done it before on other cases that were also very serious cases. I'm sure I can get the funding.
All right, thank you.
And frankly, if we didn't get the funding, we would do it anyways.
Well, I appreciate that. Thank you. All right, Mr. Brooks, I'd like to ask you some questions. First of all, are you aware that Attorney Covey has filed a motion to withdraw as your appellate counsel?
Yes.
And just as a reminder, even though I tried my best to talk to you at my cameras, when I want to watch you for your response, I look slightly down to the right or even to one of the other monitors that I can look at. So I just want you to be aware that when I do that, I'm actually paying attention to you. Any questions about that, sir?
No.
All right. Do you want to have Attorney Covey withdraw and act as your own attorney, sir?
At this time, yes.
The Public Defender's Office sent to this court a letter dated February 26th of 2025. It is front and back. I think the actual filing had some additional information on the third page, but that had more to do with who was copied on the letter versus the crux of the letter. But did you receive a copy of that, sir?
Wrong. What was the date?
February 26th of 2025.
I don't believe I received that.
Mr. Brooks, would it be helpful if at this point I switch to a single camera when I'm talking directly with you instead of having the multi-camera view?
I can see you just fine.
Okay, great. So I'm just going to read the letter into the record, sir. It's important. It is from Kelsey Loshaw, the Regional Attorney Manager from the Madison Appellate Office. Does that ring a bell at all?
I think from previous letters it might, yeah.
Well, this one is specific because it was filed after the motion to withdraw was filed, and there's a requirement in Wisconsin Statute 809.30 that the Public Defender's Office advise the court of certain information. Does that help ring a bell, sir?
No.
All right, then bear with me. I will read the letter. It says, Dear Clerk, in accordance with Wisconsin Statute Rule Section 809.30 sub 4 sub B, I'm writing in response to the motion to withdraw filed by the SPD appointed appellate attorney Michael Covey. The rule requires the SPD to determine whether successor counsel will be appointed and notify the court of the determination. I ask that you pass this on to the judge assigned to the case because the judge is required by Rule 809.30 sub 4 sub C to consider the SPD's response prior to ruling on the motion. The state public defender informs the court and Mr. Brooks if the motion to withdraw Mr. Brooks' directed Attorney Covey to file is granted. Mr. Brooks will be waiving his right to public defender representation, and no new or successor public defender attorney will be appointed. Sir, have you heard what I just read to you?
Yes.
Are you aware of the risk you take as it relates to to a public defender appointed appellate attorney if this court grants the motion to withdraw.
Yes.
Do you have any questions for me about that?
No.
The letter goes on, an indigent person's right to an appointed attorney for appeal does not encompass a right to an attorney of choice or to successive appointments. State v. Evans, 2004, Wisconsin 84, 273, Wisconsin 2nd 192, paragraph 30. If a defendant decides he no longer wants to be represented by an appointed attorney, he has the choice of terminating counsel's representation and proceeding pro se, or with retained counsel. Id at paragraph 31. If a defendant elects to discharge his appointed attorney and proceed pro se, the defendant must be provided clear warnings regarding the dangers of self-representation before appellate counsel may withdraw. Id. Sir, did you hear me read the second paragraph of this letter?
Yes.
Do you understand it?
Yeah.
Do you have any questions for me regarding that?
No.
The letter goes on to provide the legal framework for the court's responsibility in determining whether a defendant validly waives counsel on appeal. And I'm going to read that paragraph. It is a direct quote from a case, State v. Thornton, 2002, Wisconsin Appellate 294, also found at 259, Wisconsin 2nd 157. For your information, State versus Thornton is a Court of Appeals case that dealt with an issue for the first time in Wisconsin in a decision dealing with the court's responsibilities in determining the waiver by a defendant of counsel on appeal. And in that particular case, and this paragraph starts out by giving a little statement about the state's summary of the issues. The state offers the following synthesis of the foregoing decisions. Before a court may conclude that a criminal defendant has knowingly and voluntarily waived his or her right to counsel on direct appeal, it must satisfy itself that the defendant is aware, 1, of the Flores rights, parenthesis, to an appeal, to the assistance of counsel for the appeal, and to opt for a no merit report, parenthesis, 2, of the dangers and disadvantages of proceeding pro se, and 3, of the possibility that if appointed counsel is permitted to withdraw, successor counsel may not be appointed to represent the defendant in the appeal. The court went on, we agree with the state that ensuring a defendant has received and understands the listed information is both necessary and sufficient to support a determination that the defendant tendered waiver of counsel is knowing and voluntary. In that particular case, the issue or the procedural posture was that the appeal was already pending, and so the Court of Appeals had some further things to say about the communication with the defendant being written. That's not applicable here. I am having a over Zoom face-to-face discussion with you, but this is the framework that will guide the questions that I ask. Do you understand that, sir?
Yeah, I'm familiar with that case. Real.
Thank you. Any questions for me thus far?
Nope.
All right. So I just want to confirm, sir, did you ask Attorney Covey to withdraw?
Yes.
Did he send you a copy of the motion to withdraw?
Yes.
Have you reviewed it?
Yes.
Do you have any questions about it?
No.
Do you take any issue or claim made by Attorney Covey in dispute?
No.
did you at any point in time tell Attorney Colby you're fired?
No.
All right.
Judge, if I could just clarify something. The conversations I've had with Mr. Brooks in every instance, they were quite respectful. There was no arguments. So when Mr. Brooks when he asked me to withdraw, it was in a polite, respectful way as opposed to a "you're fired, get out."
Great, thank you. I appreciate that clarification. I still wanted to ask from his perspective. All right. Any dispute with what Attorney Colby just said, Mr. Brooks?
None whatsoever.
All right. Why do you want Attorney Colby to withdraw?
Judge, if I may, Mr. Brooks, this question could fall into some privileged information. You have every right to answer the question. You and I have had lengthy conversations about the substance of particular issues that I have looked at and my conclusions on those issues. I don't think it would be to your advantage to go in that direction. You can definitely answer the judge's questions, but I would just be guarded as to going to the substance of any legal research that I may have done, that I did do. Thank you, Judge.
You're welcome. I appreciate that. I can ask it in a more general way. Mr. Brooks, again, understanding the caveat that your attorney has given you, how would you characterize in general terms the reason you want to proceed pro se? Is it a strategy disagreement, or do you simply just want to represent yourself pro se?
I just want to represent myself.
So let me ask you some real specific questions then about some access to research materials and other things. I believe these questions go to your understanding of the difficulties and disadvantages as a pro se appellate litigant. Most of the time, if you file in the Court of Appeals, it is a written process that may or may not include appellate arguments in front of the court. Do you understand that?
Briefly, I understand the outline of what you're saying here.
So you're prepared to follow the rules and procedure of appellate procedure and submit written submissions, whether it be to the trial court or to the appellate court related to your post-conviction and appellate rights?
Yes.
Do you have, or what access do you have to legal research at the institution at which you are currently serving your sentences?
Honestly, not very much. So it would take some time, and maybe a few conversations can be had in that area, but I mean, I don't know if that answers your question.
You've answered it, thank you. Do you understand that could lead to further delays in your appeal or post-conviction motion?
Yeah, I do understand that. I kind of anticipate that with where I'm housed. It's like I said, it's a lot different. Things are done totally different here. So I'm aware that could pose some issues.
You don't dispute that you're no longer in Wisconsin serving your sentences, correct?
I'm sorry, can you repeat that?
You agree, I earlier said you're no longer in Wisconsin serving your sentences, that's true?
I would rather not say.
Judge, I can verify that he's no longer in Wisconsin. The Department of Corrections had requested me personally not to disclose his location. Of course, it's up to the court.
To reflect that Mr. Brooks is back in the courtroom. I do want to make a further record that he still remains in his jail attire. Prior to the break, I did advise the captain and to let Mr. Brooks know that he certainly could take the opportunity during the lunch hour to put on street clothes. So it's his choice. He is here in the jail attire. He's at the table, continues to be masked. Welcome back, Mr. Brooks.
They never asked me during the break because I had so much other stuff going on. I'm not sure. I'm not saying it was intentional on their part, but I was never asked. I just want to make that clear for the record.
Thank you. I appreciate that clarification. Nonetheless, I provided you with that opportunity, and here you are. Please be mindful, sir, that the right to be here can, of course, be lost if you engage in disruptful, discourteous behavior, if you interrupt the decorum and do not show respect for the judicial proceedings. You would, of course, be subject to removal and forfeiting your right to be present in this courtroom. All right, I'd like to bring the jury out, Mr. Brooks. I am still going through the preliminary jury instructions. I know you filed some objections. Those have been noted for the record, as I advised earlier this morning. Because I've approved of them, there should be no objections. You had ample opportunity to do that. So I'm instructing you at this point not to object, because I will consider whether that's being done for disruption. If you have an objection, write it down on a piece of paper, pass it to the bailiff, and I'll take it up outside the presence of the jury.
Just so I'm clear, are we talking about objections to the strictly jury instructions or the filing that I filed on the 3rd?
I'm not addressing those at this point, sir.
I was just asking for clarification. I didn't know which one you were speaking on as far as the objections.
I'm talking about objections during this court hearing to the court going through the preliminary jury instructions.
Okay, I was just asking for clarification.
I'm not addressing any of those filings. I previously addressed those. It may not be to your satisfaction, but
What you said, to be honest about those.
and I'm not going to repeat myself. So the record speaks for itself. Your objections in those filings, to the extent, whatever they are noted. They're part of the record, and they will be available for you at a later point in time should you be convicted and on appeal to make whatever arguments that you need to or want to regarding those. But from my perspective, that is something I'm not going to take up any further. And any attempt by you to do that, I will have to consider whether that's being done to disrupt the proceedings and not for legitimate reasons.
The reason for bringing it up was to make sure that they are offered into evidence.
Sir, we're not at the evidentiary phase. They're part of the record. They've been received. So at this point, there's no evidence to be taken. We're not at that stage of the proceedings. So you will have an opportunity after the state presents their case in chief and they rest to then present your case and to present evidence that's relevant to the issues before the court and the jury. So I'm not going to go through any further on what that means. That would be for me to provide you with an explanation of the law or procedure, but I expect you to not bring that up at this point in time or going forward.
I understand, Your Honor.
Mr. Brooks, I've already addressed them. I'm going to bring the jury out. Please do not disrupt as the jury comes in and as I complete reading the preliminary instructions. I am, just for reference for everyone, I've read through 44 pages of 69, and so I still have a ways to go. My intention would be to finish with the preliminary jury instructions, take a short break for all, including the jurors, and then come back with opening statements And that's, you have a choice, sir, at that point, whether you want to give one, but the state goes first because they obviously have the burden of proof. And then you would have an opportunity to give an opening statement as well. But that's my plan, at least for the afternoon.
I would like to go back over there, Your Honor.
You would like to, you're asking that to voluntarily be taken to that courtroom.
I'm trying to seek to understand how the testimony evidence that was given could be
Mr.
considered.
Brooks, I've already dealt with that. I'm not going to deal with it. If you want to go to that courtroom, are you waiving your right to be present right now?
Can I at least raise the issue of subject matter jurisdiction?
No, there's no lawful motion before the court. You may not.
Are you making a judicial determination that I cannot?
Mr. Brooks, I'm going to bring the jury out. I'd like you to stay. That's my preference that you stay. You've certainly demonstrated throughout these proceedings that you have the capacity to follow the rules, that you have the intellect to make cogent, coherent, articulate, responsive arguments when you so choose. But when you start doing what you're starting to do right now, going back to filings I've already addressed, and start talking about subject matter jurisdiction, that is a tactic by you that I believe is to disrupt and to delay the proceedings.
That is not accurate, Your Honor.
Your objection to my characterization of that is noted.
I would like to make a motion for finding a fact then.
Your request is denied.
On what basis?
Your request is denied, sir.
Your Honor, I'm merely seeking to understand on what.
Mr. Brooks, I refer you once again to document 244 that you signed, that you acknowledged, dealing with the right to waiver of right to attorney. We went through all of the advantages, the disadvantages. You were advised of things, including the charges that you face, the penalties that go along with them. We discussed the difficulty of representing yourself. You made a deliberate choice to waive your right to an attorney, which this court honored and granted. And you, Mr. Brooks, don't interrupt me. Okay, now that's at least the second time. So don't interrupt me. I'm going to continue with these proceedings. Even though you're mild-mannered, even though you're speaking in a soft tone of voice, the conduct still has the same effect. And that's to disrupt, to delay, and to show disrespect for the court proceedings.
It is not my
Mr. Brooks, please, I'm not going to force you to sit down. You're welcome to sit down, but I am instructing the jury to come out. You, at your peril, run the risk of me admonishing you in front of them at this point. I don't want to do that, sir.
I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that you want. All right?
I'm not asking for legal advice.
I cannot explain court procedures or the law to you. So with that, Mr. Brooks, that's another interruption. You keep going. Stop.
I'm seeking merely to understand, Your Honor. I don't understand the nature and cause of the charges.
Mr. Brooks, I've already dealt with these.
Bring up the subject matter
Mr. Brooks,
jurisdiction.
if you keep interrupting me, then you will forfeit your right to be present because you're showing through your conduct that you will not follow the most simplest rule of civility in a courtroom, and that's by not interrupting. You continue to interrupt. It's been a couple of minutes since we've been on the record, and there's been a number of times you've already interrupted me. You claiming to not understand, and you wanting to discuss subject matter jurisdiction, do not, it's just a tactic by you. The fact that you are doing that demonstrates to me that you came back over here, right, with absolutely no intention of following the rules.
If that's what you want to say, that's your assessment. It's not accurate.
Well, my assessment will stand on the record, sir. It's based on my observations.
And
So at this point, Mr. Brooks,
I respectfully object
stop
to that.
interrupting me, please.
I merely
Stop
just seek to
interrupting me,
understand.
sir.
I'm not. I was
If you have an objection, write it down.
I thought that applied to me being
It's applying right now since you keep interrupting me while I'm talking.
So what is the purpose of me being present if I'm not able to ask simple questions that I do not understand? I'm
Mr.
just
Brooks,
seeking,
I've been
I'm not
more
asking for
than
legal
patient
advice.
with you. And the issues that you keep trying to raise every time you're in here are not issues I'm going to raise at this juncture or address at this juncture in the proceedings.
Is there
All
a
right,
reason why?
I'm not giving you advice, I'm not explaining the law, I don't need to do any of that, sir. All right, you filed what you needed to file, I have addressed every single filing on the record. It may not be to your satisfaction, but I have addressed them.
That's
All right,
inaccurate, Your Honor.
some of your
With all
filings,
respect.
sir, you're interrupting me yet again because you're not letting me finish with my explanation. Some of your filings do not require a specific line-by-line response by the court. I've addressed them in the way that I believe the law requires me to do. Again, that may not be to your satisfaction, and that is simply the way that it's going to be. But we are continuing on with the reading of jury instructions. It's important. They're going to come in, and it will be up to you whether you can demonstrate respect and courtesy, not only for these proceedings, but for the jurors that have been selected to hear this case. Madam Clerk, have the jurors brought in, please.
You're doing this with judicial misconduct. You're making the judicial determination, and I'm not allowed to ask questions. And I'm not allowed to question Your Honor, which is my right. I've merely brought up subject matter jurisdiction because it has merit. I've merely tried to seek to understand the proceedings that I do not understand. You're rushing me to judgment by constantly removing me from the court when I should be present for all proceedings, and I should be able to understand, which I do not. Once again, I do not understand the charges, the nature of the charges against me. I do not understand why Your Honor will not answer mere questions that would give me clarification on understanding. I'm not attempting purposely to be disruptive, disrespectful in any manner. But if I don't understand something, it benefits me to ask so that I can have clarity. The waiver that you speak of with the attorney, I gave the waiver back in the way that I felt that it should be altered, and you said so yourself on the record that the word understanding was taken off of that paperwork that I sent back to you. That should have let you know right there further that I did not understand the proceedings, and that was some of the issues that I'm bringing up now. It's merely just clarification, Your Honor. I don't understand what is going on. It's not to be disrespectful. It is not
Mr.
to
Brooks,
prolong the proceedings.
do you
It is not to-
understand when I tell you not to interrupt me?
No,
Do you
no, I do not.
understand when I tell you you need to follow the rules of decorum? I believe you do. Please sit down. The jury's coming in.
I still would like to ask
Mr.
questions,
Brooks?
Your Honor.
Stop talking. We are proceeding with the continued advisement to the jury of these preliminary jury instructions. Do not interrupt me. The record should reflect that the jurors are entering the courtroom.
Your Honor, with all due respect,
Mr. Brooks, stop talking. It's not appropriate at this point in time. You'll have opportunity later to raise other issues, but the issues that you seek to engage with this court are issues I've already addressed.
You have not shown proof
Mr.
that
Brooks,
you have
the
not
jury
shown.
is in the courtroom.
I understand that,
You
Your Honor.
continue to talk despite being told to sit down and to pay respect to this court, to these jurors, to the process.
It is my right to stand or to sit, Your Honor. It's my right.
Mr.
I'm
Brooks,
merely
you can
exercising my
stand,
right.
you need to be quiet. Thank
Your
you.
Honor, Your Honor.
Mr. Brooks, please stop. I'm going to continue with the instructions. If you interrupt me, you will run the risk of being taken to the courtroom next door.
I'm seeking to understand, right?
Mr. Brooks, final warning.
I'm seeking to understand, right? It must be some clarification.
Mr. Brooks, I want you here.
I want to
Stop interrupting me.
be here. You were quiet. I didn't.
Mr. Brooks, stop talking so I can read through the instructions.
Your Honor, can I?
Ladies and gentlemen of the jury, I'm going to continue with the jury instructions.
Where you at? Where you at? I'm like, look, I'll meet up with you to get the money and, you know, give you a hug or whatever. But she was like, well, D, I need something. I'm like, no, we can't do it all that. I'm not going to have sex with you. I'm not going to hang out with you. Or none of that.
All right. So you told her you weren't going to do any of that stuff.
No.
How did you set the meeting up? Did you talk to her on the phone, Facebook Messenger, text message?
I talked to her.
I don't think she said anything about that. So just, I mean, if she's BS, how did you
Yeah, because this is what she does.
Hold on one second. Hold on, one thing at a time. How did you set the meeting with her? How do I verify?
That's what I'm saying. If she can't get in touch with me, that's what she'll do. She'll go to social medias and do all this and try to talk to people and all this and that. I got in contact with her through a mutual friend that we both know. And I was like, okay, tell her I'm out in Waukesha or whatever, and I'll meet up with her to get the money. And then she put us on the call. And she was just like, where you at? Yeah. And she was just like, where you at? I'm like, look, I don't know where I'm at. Do you still got that money? She's like, yeah, I want to give you the money, and I want to do this and do that. I'm like, no, I'm not gonna hang out with you. I'm gonna meet up with you, get the money, give you a hug and kiss. We'll talk later.
Was it still daylight?
It was still daylight. It was still daylight. So this was, I think the game was still on.
It was on.
The game was still on.
Stephanie used to go.
Yeah. The game was still on. So I was like, fuck it. You know what I mean? I want to see you. I ain't seen you in like a month. You know what I'm saying? So I'm not going to lie and say, man, that's my baby mama. I love this woman. But I can't hang out with you. I can't do anything with you. You know, that type of thing. You know, and whatever the case may be. But yeah, that.
And this is on your cell phone? The three-way call, obviously it's your cell phone because you're not on, right?
My friend's phone.
Friend's phone.
Yeah.
But yesterday, so do you have your phone?
No. That's what I'm saying. No.
So who is the car anywhere. So just, every hour or so, my boss, he knows out here, I just gotta call him, say, yeah, we're talking, I'll call you back later. Just gotta step out, throw in a line with him, and we'll come back. Just chill out here, enjoy your soda. We'll be right back. All right? Sound good? Okay.
So we done talking or?
No, we'll come back. Just chill out, and we'll be back. So I just gotta make that call.
That check-in call.
All right?
In the middle of the conversation.
Well, do you wanna tell me about the car?
Just go another couple minutes. Yeah, but
I mean, I gotta call him, I can come back, but I just...
listen, I'm willing to listen, Carmen. You've been straight up with me. You've been straight up with me, right? All I'm saying is I just want to know what I'm looking at and if I can just notify my girls. That's it. I don't have a problem with talking to you guys at all. I just want to know what am I looking at. That's it.
Yeah, to start, she called about some domestic abuse related stuff. Now, I didn't talk to her myself. I told you that at the start. You said she was crazy. We talked about
Y'all know that. Y'all talked to the woman.
No, I didn't. I didn't.
Oh, I apologize. You talk.
Darrell. We listened to the interview. Slow down, Darrell.
Did she look beat up? Did she look like, dude?
Darrell.
Come on now, man.
Slow down. All right? We can't explain it to you if you keep talking over us. You know what I'm saying? All right? I didn't talk to her. I didn't see her. Okay? Now,
Okay, with regard to that clip, sir, we have a lot of talk about her, meeting her. Who is her?
Objection, leading.
Overruled.
The her in this case is Erica Patterson.
So did you have some conversations with Mr. Brooks before this clip about his relationship with Ms. Patterson?
Objection, leading. I do consent to be in court that night.
The objections are overruled. The witness may answer.
Yes, I did.
Now, at the end of this video, not the end of the video, but the end of this clip, again, he is saying, what am I looking at? Do you recall him saying that in this video?
Objection, leading.
Overruled.
Yes, I do.
Was this a theme throughout this 5-hour video?
Objection, leading.
Overruled. The witness may answer.
Yes, it was.
Did he, you had stated initially when he came into the room, he had complained about some shoulder pain.
Yes, he did.
Did that continue throughout the interview?
Objection, relevancy.
Overruled. The witness may answer.
So, I would say what happened is it went on and off. So at this point here, the interview at this point in time was what I would describe as laid back. A lot of it was simply getting background about the overall relationship between Mr. Brooks and Ms. Patterson. During that time, he was fine. He was moving his arms, as you could see in this clip. He wasn't complaining about pain. What I noticed and made me question the legitimacy of the injury before ever actually even seeing the body cam is I noted at times of stress later in this interview as I continue to push on a vehicle. I can see, as you could see here, I believe, it can be seen here in this interview, talking about the car making him uncomfortable. Complaints about the pain would suddenly come back.
How about the request to be told what he's looking at? Did you see any correlation between that and what was occurring during the interview?
Objection, speculative.
Overruled. The witness may answer.
Yes, that, as I say, that continued throughout the entirety of the interview, and really at this point was a little unusual because right now he had been told he was looking at the domestic. The parade hadn't come up, so a reasonable person, I believe, at this point of the interview knew what they were looking at. They were looking at a domestic abuse incident. Why simply asking him how he got out here as far as transportation made him nervous was alarming.
an example of him, you said that you had seen him using his arms a little bit in this clip, is that correct?
Objection, leading.
Sustained as to the form of the question.
You had stated that, what observations did you make during this clip about the use of his right arm?
He would move it from side to side, so, I mean, both his arms would come out like this and move. He would make mannerisms when he was speaking with both arms that were, to me, what a person would do when they're normally conversing. And it would seem unusual to make those movements if he was, in fact, in as much pain as he was claiming to us he was in.
Now I'm gonna just let the record reflect that when you had indicated he'd move his arms this way, you moved both your right and left arm out parallel to the ground at about shoulder level. Would that be accurate?
Yes, it would.
I'm going to show you a clip beginning at 52 minutes and 15 seconds to 52 minutes and 42 seconds, so a very short clip. Go ahead.
That, and then she makes this complaint when she gets you back.
Yeah, and it's like, why are you just doing this to me? And I promise you, my right hand to God Almighty on the throne with Jesus next to his side, the woman is going to sit up there and say, I was drunk, I was mad, blah, 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 blah. But it's like, now I got to go through everything just for you to do that. Why did you do this to me?
She thinks she's going to come back to us.
So we saw some motions with his arms during this clip. Would that be an accurate statement?
Objection, relevancy.
Overruled, the witness may answer.
Can you explain to the jury what you observed?
So I observed Mr. Brooks move his arms to his side, above his head, his right arm almost fully above his head at points. Quite frankly, showing that arm seemed to have full range of motion.
Now, you testified yesterday, you had seen a video or a still shot from a video, and you identified the defendant driving a red SUV. Do you recall that testimony?
Objection, leading.
Overruled, the witness may answer.
Yes, I do.
And when the defendant was telling you about his friend bringing him out in a tan Kia, I think he said, did you believe that to be true?
Objection.
Sustained. It's for the jury to determine credibility. The witness will not answer that.
Did you ever see any video of the defendant driving in a tan Kia during the time of the parade?
Objection. Hearsay.
Overruled, the witness may answer.
No, I did not.
Directing the video to 1 hour, 4 minutes, 30 seconds.
Four, 6, 7. Oh, wait, hope if I have my freaking phone somewhere. 4, 6, 7. 6, 7, 85, 31, know that park. I know that park is by old girl's house. By whose house? Yeah, Hardswood. I don't know the name of the park, but it has like a little creeker. It was something going on out there yesterday to where a lot of shit was blocked off. I don't like I said, I don't know about Waukesha, I don't know, but it seemed like everybody was at that park kind of walking around that creek.
Like a playground type park or like a
park. It seemed like a little creek or something. Well, I don't know if you would say a creek. What would that be? But river? Would that be a river? Is Waukesha have a river? Well, I know it's a small body of water. It's like, how would I describe it?
But there were barricades blocking some shit off here there?
No, it looked like in that area. In that area, it looked like a bunch of shit was like blocked. You couldn't go down certain streets or some shit. I don't know, but that park is close to the old girl's house where that's why I said, look, when our friend was like, you know, your baby mama trying to get in touch with you. And I'm like, yeah, what's up? What's she telling you? What's going on? And she was just like, well, she said she got some money for you. And I was like, why would she tell somebody else? That's what I started thinking at first, like, that's, like, why would you think, because she'll tell me the same thing, don't tell people our business. So then when she put us in, when she merged us in, you out here, you out here, you out here. I'm like, man, yeah, but I'm like, what's up? Like, yeah, okay, cool. You gonna get, no, not staying out here like that. I'm watching the game, I'm gone.
So she tell you where to meet, or you tell her where to
meet? She told me where to meet. I said, it's a gas station right here. And she was like, is it a park right there? I'm like, I don't know. Is it a park right here? They're like, yeah, there's a park right down here, blah, blah. I'm like, well, just meet me over there. I'll get the money from you, give you a hug, give you a kiss, and, you know, I'll call you later or whatever. It wasn't supposed to be us hanging out, spending time together. It wasn't that. It wasn't supposed to be that. She got mad because I didn't want to do that. That's why I kind of figured, but like I said, I didn't see her drink. I'm not going to sit here and say I saw her drink. I'm not going to lie on her. I didn't. But when she started acting like, yeah, you finna, that's when I kind of was like, she probably been drinking. She probably having just stop drinking, but you was drinking sometime today. I know you was drinking sometime today. I didn't tell her that. I said, yeah, because she's acting too, you know what I mean? You just think you finna get the money and leave, and you must got some bitch waiting on you, and blah, 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 blah.
because I don't know. I honestly don't know. Me and my mom we was kind of having family issues for a while, so we didn't talk for a while. The issues that didn't have nothing to do with this, it was between me and her. So we started back talking when I was in Georgia. So whatever she had going on when I was on the West Coast, coming back to Milwaukee, I don't know. But I can tell you this. My mom is 60-some years old. She's never drove. She doesn't know how to drive. She doesn't even have a license. She catches the bus to work, which I don't like her doing because Milwaukee. So she has to go. She works at Freighter. So she has to go. The way her bus route goes, she has to go way until like 92nd. And somewhere she told me they don't even have a bus depot thing. So it's getting cold as shit, and it's dark out there, and she's just standing out there. And I was just like, damn, I don't want. So I'm like, you probably gonna have to change your route to catch the bus from downtown Milwaukee on Wisconsin Street, downtown Milwaukee, and then go up because I don't like her. Sure. Yeah, I don't like her doing that.
So you just argued a little bit, and then you're saying you walked away yesterday.
Yeah, I just told her, I'm not finna freaking be. It was people out there. They would tell you, I did not put my hands on this woman. I did not push this woman. I did not choke this woman. I did not kick this woman. I did not grab this woman. I did not do anything to this woman.
People out there, as in like, just regular old civilians?
Just regular civilians. Just regular,
know you.
Regular civilians.
People were by yourself?
I met her by myself.
No one from the house went with you?
No one. It was people walking up and down the street. Like I said, it was people out because it was daytime. So it wasn't like we was just in some secluded area where it was just me and her. It was people out there, and
But that was you or no?
Nobody that knows me. Nobody that knows me. I don't know if it was anybody around that knows her, but I know people were walking up and down the street. People were walking around that park.
Sure.
It was like, basically, we were out in public. Like, if we was out in public, if something would have happened, people would have, what the hell? Like, where was we going to go to not be seen?
All right, so I might have missed this. You touched on it. You were at the gas station or the park? I know the park's nearby. You met her at
The gas station. No, I met her at the park. The gas station was by the area that we were in. The gas station is by that park.
Yeah, I'm just clarifying.
Yeah.
Okay.
Which car were you in when you met her at the? I didn't meet her in the car. I walked right over here. I walked right over there to the park, and she was standing like right wherever this entrance to this park is. Like I said, it was people everywhere. So anybody would see us standing out there. She was standing right there waiting for me. I walked up, gave her a hug, and she was just like, well, my friend has my purse, so I don't have the money and all this. I'm like, so you had me come way out here with the power players? That basically was like, yeah. You know, you basically see how fast you caught on to that, and I'm just like, you had me come way out here. You know, I ain't even supposed to be around you like that. You had me come way out here to meet you. For you to try to play and shit like this, I said, no, man, I'm gone.
Yeah.
So I'm out.
It was daylight when you met up with her. Was it still daylight pretty much when you walked away from her?
Yeah, it was daylight. This was broad daylight. That's what I'm saying. Like, people outside, everything going on, people walking around the park. I'm like, anybody would have saw us talking. Anybody would have saw if anything happened. Anybody would have saw if I did something to her, she did something to me, if I ran from the scene, if I did, anybody would have seen it.
Do you know how she got out here to meet you out here? She didn't say?
She's apparently been staying out here.
Okay.
So this is what she told our mutual friend. I don't know if that's true.
All right.
I haven't talked to her and haven't seen her in like almost a month.
That's fine.
So I don't know.
You said you don't know where your phone is. We're talking your cell phone, right?
Yeah.
You're not sure. Did you leave it? Do you keep that with you? Is that your phone that you have with you all the time? Because you seem, I don't know where it is. I don't have it. You seem confused. It's missing. Is that something?
Yeah. Well. Yeah.
Like if you go somewhere, do you take your phone?
Absolutely. My mom just got me
we did stop at 1 hour, 18 minutes, and 2 seconds. Sir, with regard to this clip, you asked the defendant about his phone, correct?
Yes, I did.
Did you know where his phone was when you asked him if he lost it?
Objection. Hearsay.
Overruled, the witness may answer.
The phone was found inside the vehicle, so he didn't have it with him when he was taken into custody. The red Ford Escape.
Overruled, the witness may answer.
I'm sorry, the red Ford Escape.
And in whose name was that car registered?
Dawn Woods.
And what relationship is Dawn Woods to the defendant?
Objection.
Overruled.
She is his mother.
Did you question, your question about the phones, what significance, if any, did that have to you? Or why did you ask him about the phone? Strike the initial question. Why did you ask Mr. Brooks about the phone?
Objection. I don't consent to being called that name.
The objection's overruled. Go ahead, you may answer.
One, to verify his contact information, but two, one, if we were to find the phone, it would help us know whether it is his. And if we were able to find a phone and we know it's his, knowing the phone number, including make, things of that nature, can help be used in location services at a later time to further verify that the suspect was, Mr. Brooks, was in Waukesha at the time when these incidents occurred.
And again, at the time that you asked these questions, did you know that the phone had been located in the car, or you did not have that information at this time?
Objection.
Sustain us to the form of the question.
What information at the time that you asked Mr. Brooks about the phone did you have about it?
Objection. To the name.
Overruled. You may answer, sir.
Very little. At that point, I don't recall if I knew that the phone was inside of his mother's vehicle.
Okay, thank you. Now directing you to the mark of 1 hour, 19 minutes, and 20 seconds to 1 hour, 38 minutes, and 30 seconds. Let's play that portion of the interview.
She drinks. So after you talked to her, Darrell, where did you go? Do you have they found it was cold yesterday. You didn't have a jacket. Did you have a jacket with you?
I didn't initially have a jacket because, like I said, I was riding with somebody else. So I figured.
So you didn't bring one in anticipation of the
cold? I didn't because I figured I'm going from the house right to wherever we're going. So to me, it wasn't like I'm gonna hang out with y'all all night type of deal. We was just supposed to be watching the game, having a few cold ones, and then I was getting dropped back on home.
So what happened, Darrell, when you ended up? So I know you say you're not familiar with the area
at all.
I'll lay this out for you. So follow me for a minute. You say you're kind of near this park. I got an idea in my head of where you're talking, based on my knowledge of the city. It's right near Stephanie's where you're hanging around watching the game and Marcus is there. You came out here with your phone because you take it with you. How did you end up at this guy's house? Now you said when you walked away from Erica, did she go the other way?
You walked away. From what I remember, she just stood there.
Okay, so
she was just standing there like.
Right. away from Stephanie's. Okay, I can tell you that based on my knowledge of the city, based on approximately where you're telling me it is, without your phone in your shoes. You understand where that's kind of weird? How did you get to be over there? What happened?
What basically happened with that was when I got back over here by old girl house, I just said, because I don't really know Stephanie like that. It's my friend or partner or whatever the case may be. They was getting into it about pretty much the same thing that I was getting into it with Erica about. I was just like, who's him? Marcus. Him, her, and whoever else, Stephanie.
Was there anyone else there other than
Yeah, at her house, yeah. A few girls that I didn't know, but they had already said it was gonna be people over here.
Okay. All right, so
I was pissed because I feel like I just met up with her, with my baby's mama. I just met up with her for absolutely nothing. So you tell me, okay, you out here in Waukesha, I'm out here, let's meet up, I got your money, and then I walk over here and you don't have the money. Or you do or you don't, you just ain't gonna give it to me. However the case may be, so I'm just like, okay, whatever.
well, hold on.
So when I get back,
you're pissed, but
when I get back over there, I'm pissed. They was getting into it, and he like, man, come on, bro, we just finna go. And I'm like, what the fuck going on? Like, I just got into it with it. Now y'all into it, like, man, this bitch tripping, whatever, let's go. I'm like, nah. No. I'm like, I'm out, dog. And I just started.
Marcus wanted to leave?
He wanted to leave, but I don't know what the fuck he was on. He probably didn't even get into it with old girl, but he out there like, man, let's just go, bro.
How long have you known Marcus?
I know Marcus for years.
Okay. I'm gonna be straight with you, because you've been asking me for that all along. That doesn't make sense. Listen to me, okay? Just listen to me. You go to this house. You leave. That wind was cold as hell.
Not at first.
Well, by the time it was getting later in the day, I mean, after the Packer game, you're talking 3:30, 4 o'clock, it was getting cold. I was outside for a while.
Yeah, about like
So, by the time you're talking, it was getting cold. All right? Marcus is ready to leave. Because this bitch is being crazy. He's like, I'm out. You just went through the same experience from what you're telling us. You live in Milwaukee.
I don't know what exactly happened. a jacket. I had flip-flops. Green Bay Packers flip-flops. Right, because I didn't feel like I was going to be like, I'm not going to be outside. But I'm thinking I'm not going to be outside. If I'm just going from a car to a house, there's no reason for me to have a coat on, or at least that's how I'm thinking. I always do that. That's just like if I had a car and I know I'm finna go somewhere and I'm like, I'm just going from here to there. Well, there's no reason for me to just get all bundled up and do all this and that. There's no reason.
Were there still a bunch of people out when you left? When you left her house?
It was still daytime.
Okay, you said there were a bunch of people when you were talking to Erica. There were still a bunch of people when you left Stephanie's.
When I was I wasn't talking.
When you left Stephanie's,
it was still daytime.
It was still daytime.
Yes.
Okay. Were there still a lot of people out?
It was still people out. Okay. It was still people out. Not a lot in that area. By the park, it was a lot of people out.
Okay.
Like I said, it looked like something was, I don't know what the hell. But it was a lot of people out. And it was people, like I said, it was people, it was older couples walking down the street. It was younger people walking down the street. People
Was it an event or something was going on?
I don't know, but it kind of seemed like it was a lot, like it was something going on to where it was vibrant. Because there was a lot of people everywhere.
Walking up and down the street.
Everywhere. Just people. That's what I'm saying. Like, if I got into a fight with her right there, it would be impossible for somebody to not get this. How could somebody not see something?
How long was it between leaving Stephanie's and those cops yelling at you at the door of that guy's house?
Was it dark when they yelled at you?
Yeah, by the time they came, it was dark.
Okay.
But we had been sitting out there. We had been sitting out there for a minute, me and the guy. We were just sitting right there on the porch. We were just sitting there.
Find how long? Estimate.
Maybe 20, 30 minutes, maybe. It wasn't long, but it was long enough for, like I said, he let me use his phone. We sat on the porch. We were sitting right there, just like this, just sitting on the porch. While I called me an Uber. I called the Uber. I said, look, man, I let him know. I said, look, I ain't trying to ride him like that. When I knocked on the door, he kind of was like, whoa. I'm like, look, I don't got no weapons. I'm not trying to break in your house. I'm not trying to rob you. Nothing like that, dog. I just need to call an Uber. That's it. I'm not, he was just like, okay, I'll come out. Boom. I need an Uber to, what's your address? He told me the address. And we was just sitting there waiting. That's how I was going to get back home. I told him, I said, I got the money on my card. I'm not asking you for no money. I just need to use your phone. That's it. That was it. That was all. And then from there, we sat on the porch and just shot the shit out.
I'm saying, you told me last night he was cool with that. Like, he wasn't being weird. He was just like, oh yeah, I'll help you out.
Yeah, we just sat there on the porch. And he did ask me, he said, do you need a jacket? I said, no, I'm straight. Like, I be home, as soon as the Uber come, I know it's probably going to cost me probably like $40 to get from me. I'm guessing. I don't know, but but I had enough on my card to where I knew I could get home. And that was the main thing. I'm like, I'm just going home. She can keep the money or whatever. I didn't even try to contact her further. I just was like, I'm calling this Uber and I'm going home. That's it.
Let me ask you this, girl. So you weren't out in Waukesha Saturday, just Sunday.
Yes, sir.
Okay. Nothing physical yesterday. Like I told you, you're a part of the investigation. There's a lot of parts, right? In the investigation, there's what we thought. Well, this domestic abuse thing I'm telling you about, right? Okay.
So wait.
Hold on. Let me go. I'm sorry.
I just had a question.
You talked about being a religious man, right?
I can do better. I can definitely do better.
We all could.
I'm not.
We all could. That's why.
Yesterday was a mistake. I should have just freaking watched the game and just fucking went home.
Right.
Because.
That's the thing. What do they teach us in Christianity? Throughout it, they teach us that we're broken, right? We're sinners. Even when we're born sinners. We're broken. That's why
Psalm 51,
we're so
17.
thankful for God's
you were out yesterday hunting, and just let me finish. But you did not walk to that house. You did not walk to that house. You did not come here in a tan Kia. You didn't. No, you did not come out here in a tan Kia. Okay? You got a key in your pocket to a car, your mom's name. Okay? And that key works for that car. For the love of God, Marcus. For yourself, for your family. You know what happened yesterday for the people. Tell me what happened.
With what?
With the car.
What am I being
With your mom's car. You're driving goofy, people called in, you drove out of there in your mom's car, the red car, you're driving a little silly, probably because you're pissed. You met up with Erica in the car at the park. Now initially I believe you told us the gas station, do I have that right? And then you changed it to the park. So that's an
No, I said the house was by the gas station. When you said what was by.
You said you went and it was by a gas station, that's where you met her.
No. I said I met her at the park.
Okay.
At the
Well,
creek.
you met her,
You say it.
met her at the park in your mom's car. A red Ford Escape. She got in, you talked, and what you're telling me seems pretty consistent, that there was nothing physical between the two of you.
No.
But you met her in the car.
I didn't put my hands on her.
But you met her in the car.
Kim, what's going on, man?
I'm asking you a question.
Just be.
You were out there
Just tell
driving
me
kind
what's
of
going
crazy.
on.
Some people said you were driving kind of crazy. I got reports of it. You got the key, you got the car. Did you take the car or did your mom give you the car? I know you know what car I'm talking about.
I just want to know. So
people
now
reported, all those people reported that car driving a bit erratic.
I know what you're saying. All I'm saying is this. We all been straight up with each other. You knew it was more to what you was asking me yesterday.
Didn't know
that would explain the FBI and all that, right?
They're not here today. So if it's that big a deal, you don't see them here today.
Come on, Kurt. We been.
You guys met in the car in the park.
We've been cool, man, the whole time. If I did something wrong,
that's why they were here. But do you see them here today? They're not here today.
Yeah, but y'all lied to me, man. You make it seem like they just come for no reason.
Well, here's the thing, Darrell.
And I'm like, what?
Listen for a minute. I apologize. I can give you a clean slate here.
I apologize.
Because you have lied to us as well. Because you came out here in the red Ford Escape. Okay, that is what you came out here in. You had the key. Alright? So, what I want to do is try to give us all a chance to reset. You understand what I'm saying? Start over. Because you're not giving us an accurate story. You didn't ride out with Marcus in a tan car. You said your mom doesn't have a car. I just told you we've disproven that. Alright? I don't know what kind of woman she is. I don't know what y'all have been through. But you were seen in the car driving kind of acting a fool. Okay? In basically the same area that you've already been able to describe for me. I'm just trying to figure out how and why it happened. What made you tear out of there? What made you so mad where you're like, fuck it, and you raced on out of there? And then people go, man, this guy's, he's driving around here kind of fast.
All I want to know, like I said, y'all been cool with me. Am I charged with anything? That's all I want to know. I'll tell you anything you want to know.
Right now,
listen.
You were driving a bit slow.
Listen. No, I don't drink.
You said you had a couple cold ones during the day.
Yeah, but I'm saying the hard alcohol,
video stopped at 1 hour, 38 minutes, 30 seconds. Detective, can you explain what was occurring here during this clip?
The objection's noted, it's overruled. Go ahead, you may answer.
So in this clip here, my goal and intentions were with Mr. Brooks to start getting into the details of him driving the red Ford Escape through the parade route, and to begin confronting him with information about the Ford Escape key that had been found in his pocket. Obviously, to this point, Mr. Brooks had told us his mother didn't have a vehicle that she let him use. He didn't know if she had one at all. The vehicle was in his name.
Or is it his name?
I'm sorry, his mother's name, Mrs. Woods, Dawn Woods. He'd stated he didn't have a vehicle at all.
The previous objection is noted. It's overruled. The witness may continue.
He had made statements earlier in the interview he didn't have a vehicle at all, that he had ridden out in the Kia, which is not true. The investigation showed Mr. Brooks came out here in the red Ford Escape by himself, so he was in fact in possession of a vehicle. He was in fact driving a vehicle. In regards to the area, you know, it should be known that Mr. Brooks's description of the park, Frame Park is the park where I should say people in the parade, wherever they might have been, lined up. They were lining up at Frame Park. Frame Park is a park that has a body of water, as Mr. Brooks described, more specifically the Fox River running through it. So he was able to describe that park. There were people everywhere walking up and down the street, just as he said. Streets were closed off via barricades, via marked squad cars, via police tape. So he was able to describe that, and the way he described the area was exactly almost how the area looked with the parade. It was extremely crowded due to the people marching in the parade. It was in fact shown to be daylight when Mr. Brooks met with Miss Patterson and then departed from Miss Patterson. That is something we learned, and I was able to confirm that based on how he described it. And you know, furthermore, you know, he describes and he gives the impression, Mr. Brooks does, that, well, if I was in a domestic, someone would have seen it. Someone would have seen it because there were all the people there, and there were, but it's not necessarily going to be seen as easily as Mr. Brooks was trying to lead me to believe, because it took place inside of the vehicle. Mr. Brooks did not walk to the park to meet Miss Patterson. That was proven as evidence in this investigation. He drove there and met up with her in Dawn Woods' red Ford Escape, which is the same vehicle after departing the park, drove along Main Street and Waukesha through the parade route.
The key found in the defendant's pocket, did that operate the red Ford Escape that was eventually located, that was registered to Dawn Woods?
Objection. That's been answered numerous times.
Overruled. The witness may answer.
There's never any depiction of a key being found in the defendant's pocket.
The objection is noted. It's overruled. The witness may answer.
Yes, it did. And, you know, as we discussed the key more, you can even hear in there that Mr. Brooks acknowledges it should have been near his ID.
And was his ID also found in his pocket, do you know?
Yes, it was.
Please wait till I rule on the objection. Sustained as to the form of the question. I'll strike the last answer. Please rephrase.
Where was that, his ID found?
In his pocket.
And the information you had, where was the key found?
Objection, Lee.
Overruled.
Objections. Hearsay.
Overruled. The witness may answer.
The key was found in his pocket.
Yeah, I think you know that.
Now, you also talked to Mr. Brooks about his phone. Where did he say his phone was?
According to Mr. Brooks, at this point, the phone should have been near him. I believe he said in the grass.
And what did you take that to mean? It should have been near him in the grass.
Objection. That was never stated.
Overruled. The witness may answer.
I would interpret it as right next to him, where he was arrested.
Okay, that's what I was just, where he was arrested?
Objection, leave.
Overruled. The answer may be given.
Yes.
After the defendant met with Erica Patterson, what did he describe his emotion as being?
Angry, frustrated over the fact that Ms. Patterson brought him to the park and did not have the money to provide him that she indicated to him prior to that she would have.
Where did he say his flip-flops were?
Objection. Answer.
Overruled. The witness may answer.
Well, when he indicated that he departed Stephanie's house, they were on his feet. However, during the course of his arrest, he indicates he doesn't know where they went. So somehow, apparently, they, I guess according to Mr. Brooks, disappeared.
Now, the clothes that the defendant's wearing in this video, specifically the red shirt, was that a shirt that was provided to him by law enforcement?
Objection, hearsay.
Overruled. The witness may answer.
No, ma'am, that's the same shirt he was wearing at the time of his arrest.
Did he indicate to you during this interview whether or not he had a coat?
Objection. So on the video.
Overruled. The witness may answer.
Mr. Brooks indicated that he did not.
And how long did he say he was on the porch with the homeowner whose house he was arrested at?
Objection. Relevance.
Overruled. The witness may answer.
I believe it was like 20 to 30 minutes.
The weather that evening, was that an appropriate shirt to be wearing for 20 to 30 minutes outside?
Objection. Relevancy.
Overruled. The witness may answer.
No, it was not.
So now I'll direct your attention to the video. I'd like to play 1 hour, 40 minutes, 0 seconds, to 1 hour, 41 minutes, and 30 seconds. If we may play that now. Go ahead.
Not touch her. Right, so what had you so mad? Because you had your mom's car. Or I don't know if you use it. Who uses it? You got the key in the car. Is it hers? Is it yours that she lets you use? Let's clean that part up. Whose car is it?
It's my mom's car.
Okay. How often do you drive it?
Not very much.
It's the red Ford Escape.
That's all I want to know. Please. Just please. Whatever you can't tell me, I understand. I understand. All I want to know, just so I can have a peace of mind, just for my girls, man. What am I looking at?
Well, the fact you were kind of racing around up and down the street, that's the first part. Right? So, we're not quite there yet. I'm trying to figure out if I've got all my facts right first. So, this wasn't a three-way call. Let's back up to there for a second. How did you come to meet her in the park?
So y'all can't tell me nothing?
Well, you were driving.
And the video stopped at 1 hour, 41 minutes, and 30 seconds. Sir, is this the first time in this interview that Mr. Brooks acknowledged knowing about the red Ford Escape.
Objection, leading, and that was not stated.
The objection's noted, it's overruled, the witness may answer.
I don't consent to being called that name for the record.
Overruled.
Yes, that is the first time.
Now, again, Mr. Brooks is asking about the charges. Did you recall seeing that on this clip as well as the clip contained within 1 hour, 19 minutes and 20 seconds and 1 hour, 38 minutes and 30 seconds?
Objection, leading, any compound question?
Overruled, the witness may answer.
Yes, I recall that.
And again, what was the significance of that question in terms of timing of both clips?
Objection, leading.
Overruled, the witness may answer.
Well, to that point, I'd been talking about the domestic abuse incident with Mr. Brooks, and I started talking to him about driving, and just driving kind of fast. I had not noted to Mr. Brooks yet at that point that he had struck anybody. It seemed to me, based on Mr. Brooks's behavior, reasonable to believe that Mr. Brooks, it was clear to me he could remember something else happening. And I could sense what Mr. Brooks was attempting to do at that point was draw out of me more information. And again, as I stated in my earlier testimony, to gauge his truthfulness, I wanted to hear what he had to tell me about the incident before giving him too much specific detail. At this point, Mr. Brooks, for example, Miss Woods' vehicle, he indicated she did not own one. He had lied to me. There is the risk if I start giving him too much specific information, he's going to create a lie about what I gave him, and so on. So Mr. Brooks kept insisting to know the charges before talking to me, but for the integrity of the investigation, that was something I couldn't and wouldn't provide him.
Direct your attention to 1 hour, 44 minutes, 30 seconds, and playing until 1 hour, 45 minutes, and 35 seconds. It is at 1 hour, 44 minutes, 30 seconds now. I'd ask that it be played.
Objection.
I want to tell you that, you know, you're charged with XYZ, you can't do XYZ. We got to, it's all fact gathering.
I feel like y'all know more than what y'all say though, and that's what has me like why should I cooperate when there's no cooperation with me? Nothing I'm saying is gonna help me.
I mean, like, it doesn't make sense to you that we're trying to gather the facts.
Yeah. Right. I mean, I'm not saying it doesn't make sense, you know,
Okay.
what you guys are doing. I'm just saying I don't want to get railroaded by people not being honest. That's all I'm saying. If I don't know what I'm looking at, it's like, what the hell? Like, why should I just sit here and be like, oh, this is everything and blah 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 blah, and then people come out and be like, okay, now so now we're gonna charge you with this and this and this and this and this when y'all do this from the door.
Well, we don't know that we're going to charge you. We're just, again, the fact gathering.
It's like,
we're asking the questions about, you know what I mean? That's why we're.
What's going on here, sir? Oh, I'm sorry. For the record, it stopped at 1 hour, 45 minutes, and 36 seconds.
Thank you. Go ahead, ma'am.
So at this point, Mr. Brooks is still continuing to try to determine what exactly, he's being charged with. And, another part of this investigation is it was so broad, I didn't know exactly what some of those charges even were going to be. I had an idea, but I didn't know exactly. And in reality, what we wanted to know at that point is where he drove, have him tell us where he drove and why he did it. But Mr. Brooks just was not willing to indicate that to us and explain that to us without us telling him what specific charges he was looking at. And this is a theme that continued over the next several hours.
Direct your attention to 1 hour, 49 minutes, and 36 seconds, playing until 1 hour, 54 minutes, and 30 seconds. And it is starting at 1 hour, 49 minutes, and 36 seconds.
Go ahead.
So your issue right now with us is you feel like we're not.
I'm getting railroaded. I know I am. No, y'all not telling me what's really going on. with me about what I'm facing. That's all I want to know. I don't want to know anything else. I don't need you guys to tell me, hey man, this is this, that is that, this is this. I just want to know. Just for the fact that, like I said, my girls.
Yeah, no, I got you. I don't know the entirety right now. So while I'm here, a couple officers talked to Erica. I'm not the only one working on it, so I don't know everything. I got a report to a boss, so I don't know exactly everything that's going to be yet. And that part's not a lie. I don't know exactly everything that's going to be yet. I'm just trying to figure out to get to that point where I can have a clear idea and call who I need to call to get some of the information to find that all out. I'm trying to get a clear idea of what really happened regarding you and her. And when you drove away, where you were going. Or did you not know? You know what I'm saying? Because right now I don't know everything.
Wow.
Because I'm out here and they're out there. Out walking.
Right, and I'm like, how long do I gotta sit in these? Where are we at?
Skigo.
How long do I gotta sit in these jails before I can call somebody? Get a phone call, let my daughters know, hey man, I don't know what's going on, but it's good to hear your voice. Are y'all okay?
Yeah, we're trying to get to that point, Darrell, but the question I asked you when you left, where were you going? Did you know or did you not know? Were you just mad and you left? Where were you going when you initially drove off? That's easy. If you didn't know where the hell you were going, or you didn't have an idea, or you didn't have a particular destination in mind, so be it. And we've been talking a couple hours. You want to sit and eat a minute?
I wish they had some Tylenol. I've been trying to fight this pain, man, since.
They might, I don't know.
They show.
I don't know how. Did you ask them?
Yes.
So they don't?
They just said they'll see. And we'll see. It hurt worse now than it did yesterday, or last night rather.
Yeah, it's gonna be sore.
It's definitely sore.
There's no doubt about that.
Oh my God.
Take a break and see if we can round up some time off for me.
Yeah, we can see if we can. How about we see if we want me to see if I can find some?
Yeah, I just wanted.
Let me see if I can find some.
It's so many things going through my mind right now. The pain, I didn't even know she called the word.
She didn't call. I think cops or someone else did. I know you said you lost your phone, or you didn't know where it went dead, and now you don't know where it is. If we find it, so we know it's yours, can get it back to you. I know you said it's cracked, but
no, well, the screen is cracked, but it has a. I don't think it went all the way to the glass.
So we know it's yours, and if we can return it.
It doesn't have a number code. You have to.
Can you draw it?
Do it with that.
Can you draw it?
It's dead. It's not even gonna turn on.
Yeah, but we don't want to give it to somebody else. We don't want to give it to somebody else. It's like.
It's a 7.
Typically,
the phone is dead, so.
Like I said, we can charge it. I don't want somebody else to say, oh, that's my phone. Even though we're giving your property to somebody else.
Wait a minute, so that sounds like y'all got my phone.
If we find it. I didn't say we had it, if we find it.
It's a 7.
Alright, so in that direction? Okay. Alright, so this way down? Okay. No, I don't know if they have it now, but if we find it, you have it, so it would think to be in somewhere in the area of that house.
And the video stopped at 1 hour, 54 minutes, 30 seconds. Can you explain to the jury what just happened in this clip?
Overruled. The witness may answer.
So in this clip, there's a couple things. First, obviously, the conversation with Mr. Brooks at this point has gotten into the parade issue, the driving issue, which is a little bit more serious. I noted that for the first time in a long time, he began bringing up pain in his shoulder again, something he hadn't been doing for quite some time up to that point. It seemed and felt deceptive, as if it was perhaps a stalling tactic. The other issue became, in the context, was the phone. So the phone that we ultimately recovered from Mr. Brooks, one was an Apple iPhone. That is the code I was specifically requesting from Mr. Brooks at this point. We have forensic analysts who download electronic devices. Those could be DVR systems, computers, but most oftentimes in our technology today, they're cell phones. And when I provided that code to Detective David Fine, who does that type of work, he indicated that could not be the code, as the Apple iPhones did not have swipe codes. They should have had numeric or facial recognition.
Thank you. Directing you now to 2 hours, 2 minutes, 30 seconds, and playing until 2 hours, 5 minutes, and 45 seconds. And it is starting at 2:02:30.
For me to look forward to, but it's like this woman, man, and I love her to death, man. I want her to be my wife, man, but I just wish somebody could tell her that. Like, I wish somebody could really tell her, like, man, this dude loves you, man. Why are you doing this to this guy, man? He literally wants to marry you. 16 years, man, off and on. I'm not gonna go mess with nobody else, man. That's the person that I want to be with, but I'm not gonna continue to be the scapegoat because you want to drink. And when you know I don't, you making it seem like I just beat up on you. Like I'm just like you're a punching bag or something. I don't wake up and be like, oh, bitch, I'm gonna hit you. Or I'm thinking, like, what? It's like almost like I'm demonized here. Like, I'm not saying you're a demon. No, not you. Not y'all saying that. But it's just, I feel that way because you're trying to just, I know you heard that. Oh my God. That fucking hurt. Sure. I know you heard that. I heard it. Check. We're gonna go check with them. Maybe they'll listen to us a little bit better. Fuck. Let's check. Yeah. Oh my God. Yeah, give us a minute. See what we got. Dude, it gotta be something wrong, man. How the hell is it?
Sometimes sprains will pop too.
Yeah, but why is it hurting like this? It makes it there's nothing.
Because sprains can actually be more painful than a break.
Whatever they did, it hurt so bad.
Want to keep the food? Why don't you keep the food and the soda and we'll be back in a few
God.
Tylenol. We'll be right with you.
And the clip ended at 2:05:45. Can you describe for the jury what you saw here?
Yes, ma'am. So what I noted is that Mr. Brooks initially, as we're in the room, continues to suggest that he's in severe pain. And once we're out of the room, there's no more groaning. There's no more grabbing of his shoulder. Rather, there's an interest in looking at the paperwork that's left behind and attempting to use the phone. As soon as that door opens, Mr. Brooks then suddenly places his face into his hands and is suddenly in despair again.
Okay, moving to 2 hours, 49 minutes, 0 seconds, and playing till 2 hours, 50 minutes, 40 seconds. And we are at now 2 hours, 49 minutes, 0 seconds.
So this is one thing between me and you, man. What if it wasn't me driving? What if it wasn't you? What if it was my mom's truck? Mm-hmm. But I wasn't driving. Mm-hmm. What if it was you? What if it wasn't me? Mm-hmm. Who else would it be? That's what I'm asking. Not asking you who else would it be, bro. Just asking. What if I knew? Mm-hmm. But I need asked to give that information.
Well, like I said, we're here together. Truth. So if somebody else was driving that car, yeah, I would want to know who that car is so we can go talk to that person. But a huge part of that is going to be your honesty with it.
Right. Now, I was just asking, because you just asked,
You've already figured out you're not an idiot. You're not a dumb man. You're a smart guy.
Right.
I see that. You know that we've been working on this.
The video stopped at 2 hours, 50 minutes, 40 seconds. What's going on here?
Overruled the witness. May I answer?
So at this point, Mr. Brooks, I've stepped out of the room, is offering up to Detective Stern that there's a possibility that someone else may have been driving the vehicle. Now, when asked about that, as we can see, he pretends he doesn't know who that person would be. It's untruthfulness, it's deception.
Hold on a second. I'm going to advise the witness to refrain from characterizing what Mr. Brooks is saying or not saying. It is solely up to this jury to determine credibility of any of the witnesses and the believability of even any statements made during these interviews. And I'm going to strike that characterization from the record. Please ask another question.
So this interview goes on for another 2+ hours, is that correct?
Yes.
Overruled, it's foundational. At this point, the witness may answer.
Yes.
Okay, sorry. Does Mr. Brooks at any time ever tell you that someone else is driving his mom's red SUV?
Objection, I don't consent to being called that name.
Overruled, the witness may answer.
Leading the witness.
Overruled, the witness may answer.
No other individual or no other name is ever provided.
Thank you. And I'll direct you to 2 hours, 57 minutes, 30 seconds, playing till 3 hours, 5 minutes, 41 seconds. It is now at 2 hours, 57 minutes, 30 seconds, and as the video commence.
It's hurtful. So you brought that up, where you don't want to see anybody wear their nose. I'll show you in a minute. You don't want to see anybody get hurt, or sorry, you don't want to see anybody get charged for something they didn't do. But you already brought up, too, that if somebody did something, that they should be held accountable that you tell the truth when you did do something. And take responsibility when you do something. There's your mom's car again. There's your mom's car again. Next to a child. I know you care a lot about children. Next to a child who's someone. Yeah. It's your mom's car.
Yeah, I was just asking him about
That's your mom's car that we took the key for from you. So you can't tell me at this point I'm playing any games anymore. You know.
I didn't say you was playing games from the get-go.
Well, you felt like
Just last,
being totally
no,
straight.
last night I felt like
It wasn't as fluid as you wanted.
No, it wasn't the flu. It was just
It wasn't as much as I wanted to.
I knew that y'all knew more than what y'all was saying, and I felt like last night with that whole, them coming in the way they did, because I'm sitting there in the thing and I'm watching them walk past, like, what in the hell? And seeing that, I just felt like, okay, y'all already know what y'all want to do, what y'all, you know what I'm saying? Y'all just won't. I didn't know what y'all wanted. It just seemed like y'all knew more than what y'all was gonna tell me. It was more so like I feel like I was being railroaded to be like, okay, tell me this, but we already know over here what we gonna do. We already know what we're gonna do right here. We just want you to tell them yourself and say you did this and did that, so we can already justify what we already want to do. And it's like I don't feel like that's fair.
What time did you come out here with the car? What time did you head out from Milwaukee to Waukesha?
I don't want to talk, man. I don't want to talk if I'm not getting nothing.
I just showed you 3 pictures.
Okay, you showed me pictures, but you're not telling me what I'm facing.
You know what you're facing.
I don't. That's the hope. That's why I keep asking.
You drove down a parade route. You got a pretty good idea what you're facing.
You see what I'm saying? So now this is more stuff coming out, man.
We told you we were looking for that explanation. And that's you.
And all I'm saying is, look, all somebody got to do is just tell me what I'm facing. I'll tell you guys whatever you want to know. I said that 3-4 times.
There it is.
And it's like, yo.
So, Darrell, what were you thinking when you went driving to this parade?
What am I facing? That's all I want to know. I don't have no problem talking with you guys.
You got people injured that had to go to the hospital.
So they're saying I injured somebody, or you're saying I injured somebody.
Yeah.
So I'm looking at what, reckless endangerment?
The very least, yeah.
The very least.
People got hurt. That's reckless endangerment. I don't know exactly what they're going to classify it. Yeah, people had legs broken. Endangerments where you may have hurt somebody by your actions. You did hurt somebody by your actions.
So what am I being charged with? That's what I'm trying to say.
I don't know exactly yet. Still working that out. I don't know all of the details. You're not going to get that out of me. I'm sorry. I'm explaining to you. Driving down there. You're looking at people got hurt. People got some broken legs.
And y'all saying that's me.
I know that's you.
How you know that's you?
Because I can recognize you. I can tell it's you. And that's your mom's car, which you had the key for. I can ID you, Darrell. I'm just asking you to be honest about it.
Be honest about what I'm facing.
What do you think you're facing?
I don't.
All I think you're facing. What do you think hypothetically? I mean, you've been through this gamut before.
Right, and y'all knew I was getting charged with this from day one, so why y'all couldn't just charge me and take me to the county jail where y'all was going to take me? Because you wanted me to tell them myself. That's basically what y'all wanted me to do.
You told us that there were reasons for everything.
No, I'm saying, but, and I'm not trying to piss y'all still, I'm not tripping with y'all, because y'all being straight up, so I'm not, but I'm saying, come on, dude, if y'all knew this already, why y'all just didn't why y'all just didn't do what y'all had to do?
Here's where you're at right now.
And it's like, you take me through the runaround to get me to do something that y'all already.
Can I speak? Here's where you're at. Okay? I'll tell you straight. Here's where you're at. One of 2 people did this. And I mean that from a human perspective. There's
God-fearing guy that you've been talking to since last night.
Then tell me the truth about
And you know that.
driving
And
down
you know that.
Then tell me
You know
the
that.
truth about driving down that
Tell me
road.
what I'm facing.
I've just told you some of what you're facing.
A son. Reckless endangerment. That's almost like saying I killed somebody.
No, you want me to give you the entire case
You
without
don't
giving
have
me
to.
anything, and I'm
No,
not going to do that.
That's not what I'm
I'm not going to
asking.
do that.
That's not what I'm asking.
Yes, you are.
No, I'm not.
Perspective.
No, I'm
Remember when I
not.
talked to you about perspective?
I'm not.
Remember when I talked to you about perspective? True somewhere in the middle, all that?
Yeah.
That's how
Yeah.
I see what you're
saying.
asking.
You got me doing all this and that, but y'all sit up here and come in here. We're not. I'm not blaming it on you guys. I'm not. But y'all sit up here. The police do this every single time. Even when you try to be, look,
Show me
you try,
that guy.
you try to be straight up with them. You try to tell them the truth. You try to do all this and that, and they still railroad you.
You're not trying
Every
to tell me the truth.
single time.
You're not trying to tell me the truth.
Not anymore. It's not even, no, it don't got nothing to do with that, because I just told you, I don't have a problem with telling you everything you want to know. I just wanted to have an idea. I just wanted to have an idea. That's all I said last night.
You know what I want to know.
And that's all I said today.
You know what happens.
Okay, what am I being charged with? What are y'all going to charge me? What are y'all going to recommend? What are y'all going to do? Because at the end of the day, I'm still, this is why I feel the way I feel. The video stopped at 3 hours, 5 minutes, 41 seconds. Sir, you had walked into this room, or I believe you had presented a cell phone to Mr. Brooks. Do you recall that in the video?
So they're on the video.
There's been an objection. I'm going to sustain it and just ask that you lay a better foundation.
Sure. Sir, you came in and you had your cell phone with you, is that correct?
Yes, it is.
Did you receive any additional information when you and Detective Stern went out of the room prior to this clip?
Objection. Others.
Overruled, the witness may answer.
Yes, I did.
What information did you receive?
Objection B.
Overruled.
Specifically the photographs that I brought into the room.
Okay. And what was on your phone?
Objection.
Overruled.
The other just can't see what's on the phone from the video.
Overruled, the witness may answer. You can ask him on cross-examination if you have questions.
So the video, or the photo I showed on the phone, if you look at the monitor right now, I'm facing it, if you face it up there, the right half.
And you can, it's a touch screen, so if you want to circle something or point to something, and you can use your finger.
Your finger, not that tool. That tool doesn't work.
Sorry, I kind of drew over it, but that half of the paper is a photograph that I was able to positively identify as Daryl Brooks, the defendant, behind the wheel of the red Ford Escape while it was in the middle of the parade route. That picture was the same one that was on the phone when I showed it to him.
Okay.
How do we know that?
We'll be able to cross-examine the witness. That statement by Mr. Brooks is, I'm directing the jury to disregard, as it's not proper testimony. Go ahead, next question.
I apologize, Your Honor.
Thank you, I appreciate that.
What were the other, what was on the other papers that you put down on the table?
So the other papers, one of them was Mr. Brooks' vehicle shortly after it had entered the parade route. That is where I specified to him he's driving past a child. There's a child towards the passenger side of the vehicle. Another one is the vehicle where it was located parked on Maple Avenue within the city. I would also note that when you look at those photos carefully, the initial one as Mr. Brooks is entering the route and passing by this child, you can see the vehicle is undamaged, where the second one I showed him where it's parked is significantly damaged on the front end.
Were those the photos, all the photos that you showed him at this time?
At that point, yes, they were.
Okay. Now, he had said twice in this, I don't know if you recall, I will tell you what you want to know. Do you recall that being stated by Mr. Brooks?
Objection legal.
Overruled. You may answer.
Yes, ma'am, I do.
What did you want to know?
I wanted to know why he drove through the route. I wanted to know what caused him to make that decision, what was going through his mind. The evidence at that point, and this is evidence, as I'm stating, it indicated his mother's vehicle drove through the route, that he was the individual driving through the parade route when the vehicle went through the route, and I was looking for explanation why, intent, motive, whatever it might be, for him to tell me, and he's not willing to do that.
This video goes on for another hour and 50 minutes. Did he ever answer that question?
Objection. Respectfully to you.
Overruled. The witness may answer.
No, he did not.
Direct your attention to video at 3 hours, 5 minutes, 57 seconds to 3 hours, 13 minutes, and 58 seconds. It is now starting at 3 hours, 5 minutes, 57 seconds.
Go ahead.
He'll probably go before a judge, right? What do you want him to think?
I mean, it's nothing not to have them think because y'all already basically saying, okay, this is what happened. We just want you to tell us that this is what happened so we can just charge you with this, which we're going to charge you with.
Are you the good guy that screwed up or the evil guy that doesn't care?
Oh, I definitely care. I
Tell me the
definitely
truth.
care. I definitely care. Why would you tell me scared like that? Just because I don't want to tell you something, now I don't care. Now I'm the malicious guy. Now this, now that. Just because I don't want to talk.
One other option. You know the truth. We've been talking for a couple.
Y'all apparently know the truth too. Apparently.
When we came in, it was to get
Man,
your
you knew this
perspective.
last night. Come on, Kirk, you knew this last night, man.
This was.
You knew this last night.
Yes, I told you.
And you could have been like, yo, some people got hurt. We want to know what happened then.
I didn't know enough details last night. There were people out there all night, processing a scene the entire night until about, I don't know, noon today.
Oh, man, y'all knew,
Till about noon today.
y'all knew all this, man.
I didn't know everything. I'm telling you, you can believe me if you want, but I got no reason why it was complete
I'm not
chaos.
saying, listen, I'm not saying you're lying.
It was complete chaos.
I'm not saying you're lying.
So that's what took so long.
I'm not.
But you know how it got to be that way.
But
So tell us how it got to be
I
that
don't
way.
even get a word.
Because we're going round and around and around and around.
We're just gonna keep going around and around.
And you're acting like you don't.
I mean,
You're acting like you don't know what these are. And you do.
No, you're making it seem like I don't care. Like I'm just this heartless type of person, dude.
Well, it
I
feels
couldn't
that
even,
way.
okay, that's fine, but look at my position. I've been in here for 24 hours. I haven't even gotten a shower, good sleep. My shoulder's fucked up. I haven't even got a phone call to even notify anybody, talk to my family whatsoever, not one time.
I'm disappointed, Darrell.
I'm disappointed too because you lied to me, Kurt.
Because
You lied to me.
you talked about what you want him to do with
Listen,
20 years.
and didn't I just say I don't have any problem telling you what happened? The only thing I'm saying is I feel like you were trying to railroad me by how you went about it. That's all I'm saying. That's it. I'm not saying.
Okay, we
I'm not
discussed
saying.
that for about an hour. So tell me what happened when you
See
drove
what I'm
off.
saying?
Wow, we're not going to make any more progress on that. I get you're pissed about that, and I'm not going to fault you for it. I'm not going to tell you not to be mad. I'm not going to tell you not to feel like, man, that was bullshit, but Carp, why'd you do that? If that's the way you feel,
A lot of people got hurt. Yeah. Are you serious? Yeah. You really were there. No, I'm saying a lot of people got hurt. Yeah, there's people hurt, man. Like that. Broken legs and stuff, like I told you. Concussions hit their head. Yeah, I wouldn't want to see that happen to nobody, dude. I don't believe you would either. Yeah, but and I'm not saying it's on purpose. You just thought, yo, this dude is heartless. So tell us otherwise. I didn't say that. I'm asking you, what do you want it to be perceived as? Tell us how it is then. If we're wrong and it's not heartless. Tell us what it was. I'm here to listen if it's something different. I'm sitting here. I haven't walked out. Come on, Hart. Come on. Y'all know. Listen, man. Y'all know. If I did not talk to that woman, I would never be sitting right here talking to y'all right now. I'm not blaming her. Like I told you, I'm not going to demonize that woman. She's a good woman when she's not drinking. It's not about her anymore, Drew. I know. And I believe that she wouldn't be in this position if you hadn't talked to her. I believe that. You have to put the picture down. You'd have to. The stroller. That's a stroller. Yeah. So a kid got hurt. Yeah. A kid. Yeah. Bad. You said a lot of people got hurt. Checked out? Yeah. A lot of people got hurt. To me, it's a pretty good injury if a doctor's got to check you out or you got a broken leg. Yeah, so what do you call my shoulder? I'm just making a joke, but yeah, I don't know. Well, I want to believe you're the man you say you are, girl, but I'm not laughing because there's nothing funny about this. No, I was just saying, no, it's not. It's never been nothing to do. I don't take my life as a joke. I don't take my life as no joke. I was just making a joke about my shoulder when you just said, you know, if it's a serious injury, if you got to get looked out. And I was just saying, I had to get looked out, but then you can say it was serious. They treated it like, oh, let's say spend the night. You're the guy in cuffs, so. Well, you said that part, not me. No, I'm just saying that's how they, not how you acted, that's how they were acting. It's like, oh, well, it's nothing broken. Well, why do I keep having this throbbing, burning pain if there's nothing wrong? Where were you going, Darrell? Help us understand something. I can do that. I just want to understand. So these parents know why their kid got hurt just the way you want to know why your kid got hurt. I want to understand what I'm looking at. That's it. A reckless endangerment. Yeah, people got hurt. Now, when you said it wasn't the end of the world type thing, because nothing's the end of the world. It is. I'll tell you why. Not when you have God in your life. It's not. It is because that's what I believe anyway. I believe that too, but you don't want to have God in your life when you're sitting in prison. Can't see your family, can't see nobody. What does it matter then?
And the clip stopped at 3 hours, 13 minutes, 58 seconds. Sir, what went on in this clip?
Overruled, the witness may answer.
So in the clip, I was continuing to try to get Mr. Brooks to tell myself and Detective Stern what occurred, explain the reasons why, understand, how and why it happened. I was more direct with him at this point and, told him that recklessly endangering safety was certainly a possibility as a charge here. I let him know that people got hurt, including broken legs and concussions, yet Mr. Brooks was still unwilling to explain to us, give us the clarity, give us the information we were asking for to understand, why he did it. despite us talking about God, I talk about Detective Stern and what, if he had injured one of Mr. Brooks's children, that's something that comes up, and what he would want a person to do if this was one of his own family members, I guess, to say if the roles were reversed. But none of those things were anything that made him any more willing to speak to us. It continued to be really demands to know what he was being charged with, even though at that point he's being told what he's very likely looking at. But that kind of back and forth just continued to occur.
At any time during the time you spent with Mr. Brooks on the 22nd or the 21st, did he ever ask how any of the injured people were doing?
Objection. I don't consent to being called that name in this leading the witness.
Overruled as to both. The witness may answer.
No. I mean, for example, I gave examples of concussions, broken legs, but there was no follow-up as to whether these concussions were going to cause people brain damage, whether the broken legs would impair people from walking again, or if there'd be amputations. He never addressed that.
Finally, directing your attention to the video at 3 hours 40 minutes to 3 hours 44 minutes and 2 seconds. It's it.
I would like that last answer by the witness strike. How can anyone determine what will happen as a result of an injury? How can you even determine that?
Your objection is noted. It's overruled. May I have that timestamp again for this clip?
Sure, it's 3 hours 40 minutes 0 seconds to 3 hours 44 minutes 2 seconds.
All right, thank you. Go ahead.
Where the charges? Let's watch that. Let's watch that for me. They say more incriminating stuff. I'm already like I'm about to lose my life, man. Can I ask a quick question? Hold on, watch it. I know. Why do you want me to watch it? Yes, I'll show you. I just want you to watch it. Watch it. Why though? Watch it for me. Why though? Because I want you to see what's in the video. Did you watch it? No. Will you? I just want to know why you want me to watch it. Because I want you to see what's on the video. Why don't you want to watch it? I just want to know why you want me to watch it. I just want you to see what I told you. You're not accepting the answer. I told you I want you to see what's in it. That's why I want you to watch it. You wanted information from us. We're sharing. I want you to watch it and see what's in it. Yeah, it's a good point. It's information sharing. Yes, I want you to watch it and see what's in it. It's like you badgering me. But Darrell, you asked me a question. Okay? And this is more than what we had before. So I am showing you more. I'm asking you to watch it. Will you watch it? I mean, I don't have a problem. Okay. I just want to know what was the reasoning. Because I want you to see what's in it. I mean, I'm pretty much... It's not complex. It's just, you know what I'm saying? It's just that I want you to see what happens. I'm just saying I already know. I already have an idea from what you guys were saying earlier. But I want you to see it. It's like watching all I'm thinking about right now is... Here, we'll talk in a second. What the hell of a journey it's been, but this is how my story ends. That's all I've been thinking about. Like, there's nothing that I want to... Look down? Why do you want me to see that card? Why? Because I think it's important. Why is it important? Is it to make, like, what is it? Why don't you want to look? I'm just asking. I'm not trying to raise my voice at you, or I'm just asking you why you don't want to look. I'm just saying, why do you want me to look? So because I think it's important so you see what happened. You told me what happened. You already told me what happened, Kurt. Y'all told me what happened. I understand my life is over. I'm trying to come to grips with that. I'm trying to come to grips with the fact that this is how my story ends. From trying to love somebody, I'll never see my kids again. My relationship is gone from me. And it's like, what is it to look at? What my life think it's important you see these. It's important for me to see my life. It is important for you to see them. For my life. Are we gonna keep going round and round about this, or is there something you want to tell me?
That is gonna help me at this point. Everybody knows what was going on. From what y'all knew last night while I was getting investigated, while I was, you know what I'm saying?
There's their children right there. Feels like kids. See that little kid right there? You gonna look at it?
Sir, and it did stop at 3 hours, 44 minutes, 2 seconds. What were you showing Mr. Brooks?
Commissioner Lee,
Overruled. You may answer.
I don't consent to that name being used.
At that point,
Hold on. Were you done with the objection?
Yeah, I was.
All right, it's noted and overruled. The witness may answer.
at that, excuse me, at that point I was showing Mr. Brooks a video that had been provided to me of him operating the red Ford Escape through the parade route. At that specific point, Mr. Brooks was struck members of the Waukesha South Marching Band, and I wanted him to see it. There was more information. He was asking for it. I felt it was important to see his reaction to it, to see if he'd be willing to talk about it. And at the point where I paused it and brought the piece of paper that his head is now down on, I paused the video at a point where you could see that it was Mr. Brooks behind the wheel of the vehicle. And the point at which I paused was a still photo of that moment that was on the paper. So it was, I guess, the same picture.
Did you get any further with Mr. Brooks in the next hour that's contained in the Zerg?
No, I did not.
Objection. I don't consent to being called that name.
Overruled. The witness's answer may stand.
On the 22nd, did you end up collecting DNA from Mr. Brooks?
Yes, I did.
How was that obtained?
Overruled.
Through buccal swab, so they're basically Q-tips out of a sterile package. I used two of them, one to swab the inside of the right inside of his mouth and the other the left inside of his mouth.
Sir, just direct your attention back to this video one last time. Did the defendant ever watch that video?
Lee.
Overruled. The witness may answer.
No, ma'am, he did not.
Nothing further.
All right, we will pause for our lunch break now. It's 12:43. I appreciate everyone's patience as we were able to at least complete the direct examination. When we come back from lunch, Mr. Brooks, you can start your cross-examination. We'll take an hour and 15 minutes, so come back at 2 p.m., everyone. All rise for the jury, please. I thank you. We are in recess.
I don't consent to called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party intervener on special appearance on behalf of my client. Can that be noted for the record?
Was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
The appearances are as they were this morning. They are no different. Bring the jury out.
And we have yet to address subject matter jurisdiction, Your Honor. I still haven't been shown any verified proof that this court has subject matter jurisdiction. And at this point, may I request an affidavit that you, Your Honor, have no bias, no conflict of interest, and no interest in the outcome of this case?
Mr. Brooks, the jury's coming out. We'll address your legal issues later, if I deem them appropriate.
Judge, do you hold the full
Mr.
judicial
Brooks,
power of the
please,
state, or is this
please.
the military
All right,
power?
can you please take the jury out? Thank you.
Do you hold the full
Mr. Brooks, just
jurisdiction?
wait till the jury's out, please. I ask that you show that respect.
I will.
Thank you. Everyone else can be, you all can be seated. Mr. Brooks, just make your statements. What do you want to advise the court today?
I want to first state again for the record that I do not identify by that name, nor do I consent to being called that name. Your Honor, with all respect, I'm merely asking you, do you have the full judicial power of the state, or is this military power?
I'm sorry? I don't understand what you're asking me, sir.
I'm asking, is
And on what
this,
legal basis are you making that request?
I'm asking for the record, is this a common law court or an admiralty court? What are we in here? And I'm requesting an affidavit that you, Your Honor, have no bias, no conflict of interest, or no interest in the outcome of this case. And the reason why I want to state this clearly for the record, mainly is because of the bias that's been shown. I have not been getting any certified copies of any requests that I've made, which I was told by this court to address inmate communication forms for anything that I may need. I've done that. I've complied with that. Every time I've needed something of the court pertaining to documents, I've done it the way the court has asked me. And I've always stated that I wanted everything to be certified. I have yet to even get that. My court docket sheet was not a certified copy. When I asked Your Honor of your oath of office, I asked for that to be certified. You stated for the record that you would not give me a certified copy of your oath of office, which you are required to show if I ask for it. I've brought up my Sixth Amendment constitutional right that has been pretty much discarded, and that is based on the fact that I have the right to face my accuser, which would be the plaintiff, state of Wisconsin, in this matter. They have yet to show that a claim is I mean, a living human being can only make a claim. An entity cannot make a claim. I've requested for the complaint to be provided. The complaint from November 23 of 2021. The amended complaint from November 29th of 2021. The second amended complaint from January 12th of this year, 2022. I have yet to see those. There was no record of a bond
in my docket sheet. I asked for that to be verified by proof. That hasn't been provided. There's so many biases, clear biases, and questions that are not being asked based on judicial determinations made by Your Honor. You look at the discrepancies, and I think they're clear. I think at minimum I deserve for the subject matter jurisdiction to be verified and proven. I've raised that issue numerous times, pretty much every day, every time I come before your court, Your Honor. I address that, and it has yet to be proven. My filings have been disregarded, even though they've been filed into the record, even though they've been time-stamped. I haven't got the original copies of any of them, which I'm supposed to get. And as we sit here today, I'm still not even understanding the nature and cause of the charges. That hasn't even been proven. Can that be provided in any way? I'm basically sitting here confused because I don't understand why these proceedings are allowed to continue when there's so many things that have not been provided. They haven't been provided in my discovery. They haven't been provided to me by being brought to my pile where I'm housed in the jail. I'm without so much information, valid information to this matter. And I believe that it should be verified and it should be proven for the record. And if not, I move for this case to be dismissed for failure to appear by the plaintiff and failure to state a claim for which relief can be granted. Everything that I'm saying, it has merit and it has validity. As we sit here today, I'm still being charged with charges that shouldn't even exist based on the testimony that we've heard for the last few days. There's so many things left to still be proven. The prosecution team hasn't even proven that they're licensed to practice law in Wisconsin. They haven't proven, are they just Bar Association members, or do they have state-issued licenses? That has not been proven, which I've raised that issue for the record. I'm not even sure if that was even recorded in the docket sheet. There's so many things, and Your Honor, you still haven't stated for the record if you have full judicial power of the state or is this military power. That hasn't been proven. Nothing has been proven. Not subject matter jurisdiction, not licenses to practice law. My Sixth Amendment right has been basically trampled over. No complaints have been shown. Neither of the three that I've requested, by the way that you told me to request them by, inmate communication. Nothing is certified that I get copies of when I clearly asked for them to be certified and to be filed into the record. It's to the point where Your Honor, you should recuse yourself from the presiding at this point. If you're not going to abide by the oath that you swore, which was in your oath, correct? You swore to protect the Constitution of the United States. You swore to protect we the people. That is not being done here. If every valid argument that I raised is taken by the court as a sign of disrespect or a sign of trying to intentionally be disruptive or causing a problem, when I'm merely seeking understanding, because I don't understand. I'm merely seeking to understand why this information has yet to be provided and we're this far into this matter. And there's still no verified proof. Even as I sit now saying this, there's still no proof being provided. Zero. How is this case allowed to continue without these documents and filings being verified? Is there any legal, factual basis that can state why this information has not been provided? why the docket sheet is incorrect, why there's so much on the docket sheet that should be on record that's not even in there. And if we had the recordings of the record they received was brought up numerous times, that doesn't even show up. I'm just asking for Your Honor to be fair, which is another right that I have, the right to a fair trial and the right to an impartial jury. I can go on and on and on about what's not being done. I have, again, I say I have the right to face my accuser. Where's the injured party? Who's making the claim? I asked Your Honor numerous times for Your Honor's name. You wouldn't answer. I asked, did you have a claim against me? You did not answer. I asked the whole courtroom, did anyone have a claim against me? No one said anything. Which you stated for the record, a non-responsive answer. A non-responsive answer is an agreement, which would be a tactic agreement by you, Your Honor, that you don't have to answer these questions that you should be answering. I have that right. The plaintiff in this matter, which was stated by witnesses in testimony to be the state of Wisconsin. But when I asked, do they see the state of Wisconsin present in the courtroom, the question is shut down, which is a valid question. The plaintiff should be present in this matter. Where is the plaintiff? Who's bringing the claim? Because we know an entity can't bring a claim. It has to be a living, breathing human being. No one is stated for the record if they're the injured party. Not Your Honor, not the prosecutors, not anyone in the court has stated to be an injured party in this matter. No one. Not one person. I have the right to demand that the court place in the evidence any unrevealed contract. Has that been provided to me? Has that been placed in the evidence? I would like to see it, which is my right. I have the right to inform the jury about the truth in their duty, in their rights. That's the First Amendment and the Sixth Amendment. But I'm repeatedly told to shut the question down when this is valuable information that the jury should be privileged to know. They deserve to know. Once they were chosen to sit on this jury, why are we keeping information away from them that they deserve to know? They ultimately have the power. They decide the matter. Why are we keeping information, valuable information, from their knowledge? That's a disservice to the jury. And frankly, it's a disservice to the court that they're not allowed to hear things that they should know, that they should be informed of. It's our right to inform them of everything that they have the power to know, to do, and to know. They deserve that much. It would be a travesty for them to make a decision without being fully informed. And these are all valid things. I have the right to protest and object if any of my rights or demands are not being met. I've done that numerous times only to be shut down. Numerous times. I've raised the issues that I didn't consent to anything that may have been suggested on behalf of my former attorneys. I've never even consented to them making a plea on my behalf. I haven't, as a matter of fact, when it comes to a plea, I haven't even had the opportunity to entertain any plea that may have been suggested by the prosecution. We haven't even talked about that. Not one time was it ever brought to my attention that the prosecution even wanted to offer a plea. That's another issue. I have the right to challenge the jurisdiction of this court, which I've done numerous times. I have the right to demand that the code be construed in harmony with the common law. I just raised that. I'm constantly referred to as pro se when I've raised the issue that I'm pro per. I have the right to conduct my defense pro per free from professional restrictions imposed upon licensed attorneys, which this court is well aware that I am not a licensed attorney. In fact, the court is also aware that I only had 3 days to prepare for a trial that the prosecution has been prepared for a whole year. We see these boxes right here. This box alone is 45 or 50 pounds full of so much information. I haven't even gone through half of it. It was stated for the record that the discovery, in its entirety, was brought to my housing unit on the 29th of September, which trial was scheduled, that would be a Thursday, which trial was scheduled for Monday. How can I possibly go through all that, all the paperwork, all the digital discovery and things of that nature? How can I go through all of that and be prepared in 3 days? That's a clear bias. I did not have time to prepare for this. Everything I'm doing is off the top of my head, winging it, taking it as it comes. When the court is well aware that I was not prepared, I raised the issue that it should be an adjournment, at least. At the minimum, it should be an adjournment because of that fact. At least to let me go through all the discovery. That was denied. No valid reason was stated for that when Your Honor knew there is no possible way, humanly possible, that I could be ready for a trial of this magnitude in 3 days. That's clear bias. I have the right to face the injured party claiming damages. That's under Article 3 and the 6th Amendment. I raised that issue again. Where's the injured party? Is the injured party present in court right now? Can anyone make a claim against me? Can you make a claim against me, Your Honor? Do you know of anyone that can make a claim against me, Your Honor? Can anyone right now in court, anyone, make a claim against me? And because of that, Your Honor, the motion to dismiss should be granted. Based on that alone, there's no injured party in this matter. So who made the claim? Who? I have the right to put the judge on notice of my intent to appeal and any ruling decisions during the case. You stated for the record that I would have to wait until the appealing process, but my right is that I can raise that issue during the case, which I've attempted to do. That's been shut down. I have the right to specifically reserve all of my rights, which I do at the beginning. I have the right to say what I want and to be heard under the First Amendment. And when I attempt to do that, it's taken as a slight to the court, a disrespect to the court, or me intentionally coming into the court to be disrespectful, which I've stated that is not my intention. Never is it my intention. I never intend to walk into your courtroom, Your Honor, and be disrespectful intentionally. I never come into this courtroom to disrespect anyone. But because I don't understand, I raise these issues because they have validity. I have the right to object to any statement made by the judge or the prosecution. I've done that and been repeatedly shut down. Without a lawful explanation. I've repeatedly asked the court for a motion for a finding of fact to determine if things are being done legally. I've been denied that numerous times without merit, which is also my right. I have the right to recuse the judge at any time, which is also a right. I have the right to a speedy and fair trial by impartial jury. I think it's safe to say that my speedy trial right has definitely been violated because this matter has been taking place for roughly a year. I've never consented to waiving anything related to a speedy trial. And if that was done, it was done without my consent or without my knowledge. We're way past the speedy trial date. Way past. When the change of venue motion was brought up, I believe that was the first time I came before Your Honor in early March. I want to say March 11th of this year, when the change of venue motion came into play. It was decided by Your Honor that wouldn't be decided until the 20th of June, I believe. That's over the 90-day mark right there for a speedy trial. That was denied, and I still don't understand how that was denied when it's clearly obvious that at minimum the venue should have been changed based on the fact of the magnitude of the matter. There's no possible way anyone in this county would not have some type of connection or some type of knowledge, whether they were told something by someone that they may know. The news reporting alone, just that alone, there's no way that this trial should be taking place in Waukesha County. That's obvious. That's obvious from the way the motion was presented, the coverage alone, the political campaign ads that plastered the defendant's face all over the TV every single day. Every time a political campaign was brought up, it made reference to this incident. Every single time. The fact that people have children that go to the same schools in this county, that people may have worked with the same people in this county. You yourself, Your Honor, stated that you at one time worked with the father of one of the people that was injured in this matter. That is a clear conflict of interest right there. You also stated for the record that not only did you work with this father, but that at one time they may have donated to I don't know if it was to you becoming a judge, or I would have to look through the docket, but you said it on the record that they donated money to a cause of yours. You also stated that when you had gained knowledge of the incident and that their family member was injured in the incident, that you reached out via phone. I don't recall if it was text message or an actual phone conversation, but you put that on the record. You also stated that the nature of your relationship was strictly professional. I don't know about you, Your Honor, but I've worked numerous jobs, and I know what professional relationships is and personal relationships. I've never had the cell phone number of anyone that was a personal relationship saved to my phone that I could reach out immediately when I learned something. That would constitute a personal relationship of some kind. Whether hanging out from time to time, having a cup of coffee, or hanging out time from time, grabbing a beer, or hanging out from time to time, watching a game, or anything of that nature. It would definitely be more than just strictly professional. That was stated for the record. again, I go back to the Sixth Amendment again. In terms of when I asked for the motion for the evidence motion that I raised, that was denied without any explanation. That would be strictly to place in the evidence any unrevealed contract. That's under the Sixth Amendment. Clearly, there's been repeated violations of my Sixth Amendment. We all know that the United States Constitution is the law of the land, period. It trumps everything. We also know that any law repugnant of the Constitution is null and void. We know that. There's still no basis for the motions being shot down. Why was I not granted the motion for finding the fact? Why did it take so long for me to be brought my entire motion for discovery? Why was the motion to prove jurisdiction not verified? Why was the motion to dismiss the case for all the reasons I said not being granted? Which brings me to the motion to subpoena witnesses. I did everything that was asked of me by the court pertaining those subpoenas. It was understood by the court that this is my first time ever having to do this. I didn't understand how to properly fill out the subpoenas, at which the prosecution volunteered that they would give assistance. The only assistance I received was for them to check to see if it was filled out right. That was it. That doesn't amount to any assistance. I was still left to fill it out on my own, and then when I did that, corrections still had to be made, which would verify what I was saying. I don't know how to do this. But I still complied to what the court asked of me. And even then, it was a big old thing about the subpoenas. I can't subpoena the plaintiff in the case. Well, how can I not subpoena the plaintiff in the case when under the Sixth Amendment, I have the right to face my accuser, which is the plaintiff of the case? So how could the subpoena not be filed, and how could the plaintiff not be called to the witness stand? That begs the question of, does the plaintiff even exist? Which it was stated for the record that not only by a witness, a Detective Casey, that got on the stand and said on the record that it is an entity, which is not a living, breathing human being. And then it was stated again by you on the record, Your Honor, that the plaintiff is an entity. So the question still stands. How can an entity bring a claim if it's not a living human being? So where's the claim? Will the plaintiff in this matter in the state of Wisconsin be allowed to testify? Would they be allowed to be in the courtroom? No, they will not, because they don't exist. Therefore, the claim doesn't exist. For all those reasons that I just stated, the case should have been dismissed a long time ago. Once those issues were raised, this case should have been dismissed. And at the very minimum, it should have been dismissed because those still have yet to be proven. We still talk about jurisdiction. That's been being asked for over a week. There's still no providing of license to practice law yet. Not even by you, Your Honor. Why was I not provided with a certified copy of your oath of office? Why would you not state the name that is on file with the Secretary of the State? Or I made reference the first time to the Secretary of the Treasury, and then you stated on the record that it's the Secretary of State, even though you knew what I was referring to when I asked. You referred to your name tag, but that's not the name registered. We both know that. So why wasn't that proof verified? You gave me a copy of your oath of office, but it's not certified. So how can I verify that that is the true oath of office that you signed? How can I verify that is valid? That's the reason why I asked for it to be certified, which you stated for the record you will not do that. You never stated any legal reason why. I have the right to ask for that legally. I also have the right to call any witnesses to assist my defense, which is the main reason why I subpoenaed the plaintiff in this matter. I also have the right to challenge all relevant laws in this trial in terms of their intent, interpretation, fairness, enforcement, and whether they serve and protect the people. From my knowledge, the design of the statutes of the law was written for the common people to understand. So that would mean the final determination or interpretation of what the law says comes down to the people. You know this, Your Honor. Are you not a public servant? You also know that this docket sheet is inaccurate. Every filing up until the point that I started representing myself was filed in a name that was represented by all capital letters, which is not my name. Nor has it ever been my name, nor have I ever seen that name or individual. Every single filing or paperwork was all in capital letters. Ever since September 29th, roughly around there, now everything starts to go to lowercase letters. Why is that? What prompted the sudden change? I still have filings that have all capital letters, which I state every time I come into your courtroom, Your Honor, that is not my name, nor do I consent or agree to being called that name. I'm merely here as a third-party intervener on behalf of my client. Did I accept for value in return for value? We go through this every time I come here. Every time. You bring up Illinois versus Allen when we had the issue of me being removed from the courtroom. We went through that where Illinois versus Allen states that there are 3 options when a defendant is being disruptive in court. You stated for the record that you identified a 4th one, which is not cited anywhere in that case. It's not cited anywhere. So the question would be, how did you come up with a 4th option that's not written in that case? Did you take it upon yourself to add this 4th option to justify denying me my constitutional right by being present? You could have done the 3 that were stated. Any one of the 3 you could have done that were stated in the case. Nowhere does it say you can create a 4th option. Not upholding my constitutional rights. I'm sure you know about Title 18, USCS 2381, which states that it's treason not to uphold your oath of office. Treason. You repeatedly make judicial determinations that clearly prejudice my defense. And then when I question you about are you making judicial determinations, I'm repeatedly shut down. Which leads to today. The constant push not to have an informed jury. Not giving legal valid grounds on objections. Not noting objections for the record to make sure that the record is clear. I'm sure somewhere in the jury instructions, you informed them that the state of Wisconsin was bringing a claim. But then you make the judicial determination that I'm not allowed to ask questions about the plaintiff. That's clear bias. And it prejudices my defense. You know also that you have an electronic filing system. I find it hard to believe that I was told yesterday about my subpoena for the plaintiff that I had to wait for a filing in a timestamp when I've seen it done numerous times in just a few seconds right in front of my face. When the prosecution needs something filed, it's filed immediately. I have to wait, or I have to wait to the next day. That's a clear bias and a clear prejudice to my defense. Obviously, the court knows that I'm not privileged to the same filing system. Which brings me to the reason why I brought up the issue of assistance of counsel. Under the Sixth Amendment, I have the right to assistance of counsel. It doesn't say anything about representing yourself without assistance of counsel. Having counsel represent you and having assistance of counsel is two totally different things. You, Your Honor, gave me paperwork that was a waiver of counsel. We both know that any contract can be altered if I don't agree to certain terms. I crossed out everything in that paperwork that I did not agree or consent to, and specifically wrote on that paperwork that I do not waive my right to existence of counsel. At the very least, I should have been awarded a standby counsel. Not someone to represent me, to speak for me, but someone to help me do things in a timely fashion. Get things filed in a timely fashion. Get motions together in a timely fashion. Make preparations to get things done that I don't have the privilege to do in my current situation of being housed at the Waukesha County Jail. I gave you back that paperwork and you accepted the paperwork that I altered, that you understood that I didn't agree and consent to those things that were altered. You accepted it and you filed it. That is in the record. I have copies of the same paperwork that you accepted. So when you accepted that, with no objection, that becomes a tacit agreement. But yet, I'm still forced to come in here with zero help. I think it's clear that prejudiced my defense. Knowing that the prosecution has everything that they need for this matter at their fingertips. And I have to jump through every hoop possible to even get things filed in a timely fashion. It was stated for the record that the unit that I'm housed in the Waukesha County Jail, and per Jail Administrator Angela Wallenhoff, that I'm only allowed out of my cell for a few hours a day. So I'm roughly locked down 22 hours a day. Not given the privilege to access everything that I should be able to at the time that I should be if I was general population. Arrangements could have been made months ago for me to be at least in some form general population with an upcoming trial. Reference was made to being able to use LexisNexis or whatever it's called. We call it the law library. That may be the easier way to describe it. I'm only allowed to access the law library at certain times during the day. The rule of the jail is that when you're not in the day room, you can't access the law library, which is on tablets. We are not allowed to have those tablets in our cells. That prejudiced my defense. How can I work on my case? How can I look up certain case laws? How can I do any of this if I don't have full access to it? I even suggested some type of order that could be made by the court to allow me more time out of my cell, or to talk to jail administration about allowing me more time out of my cell to be able to use those when needed. And to be frank, in a proceeding of this magnitude, there should not be even a time where where I don't have access to the materials that I need. If I'm not in the courtroom or sleeping, I should be awarded the time to work on this case, seeing as how I only had a couple days to prepare for a trial of this magnitude. Which brings me back again to the change of venue again. Even right now with trial going on, there's still political ads being shown every day that reference this incident. There's still talk throughout the jail about it. There's been a ton of hate mail received to the jail since the beginning of this. It did die down for a little bit, but it picked right back up the closer we got to the trial. Hate mail that comes from people right here in the city of Waukesha. Which gives more credibility to the venue needing to be changed. Yet still that was denied. It's impossible for an impartial jury to be found in this county. And that's not to discredit people in the county that can be impartial. It would be unfair to say that no one can be impartial. That wouldn't be accurate. But with the level of scrutiny that this whole incident has, the reporting, the Facebook groups, the constant, there were Facebook groups created because of this. The reporting live stream on Court TV has comment sections where a lot of insensitive and nasty things are said. The sheer insensitivity of some of the things that are said on there. I know a lot of people probably don't care about what I'm about to say, but it still needs to be said because it's truth. The fact of the matter is, that I have children too. Family too, loved ones too. That also have been ridiculed and had their names dragged to the mud and have threats towards them. Loved ones that had to leave their home because they're getting threats thrown through their mailbox. Children that didn't feel safe going to school because they were getting bullied behind what was being said. And that's not to sweep anything under the rug whatsoever. To constantly say and report this incident as attack, terrorism. It's unfair and it's insensitive. It's a definite tragedy. Definite. And that will never be swept under the rug. There's always going to be healing that has to take place. It's going to be difficult. And that should not be swept under the rug whatsoever. But it's very insensitive and unfair to not recognize that there's many other victims that never is talked about. certain picture, mostly from this county, to put this picture out there, it's not only hurtful, but it's insensitive. It's not true. I'm sure the court read through the motion for a change of venue. I'm assuming, though it was a lot of paperwork in those motions. I think it was obvious that the venue should have been changed. Obvious. It's too many connections and it's too close. It's too close. If there was any chance for a fair trial and an impartial jury, it should not have been in this county. But yet it was denied. Without any validity. Zero. There's so much bias that's going on that and even with all this, for the record, we still have no proof of jurisdiction. We still have no bond on file in the docket sheet. We still have no plaintiff. We still have no claim. We're not sure of the relationship between you, Your Honor, and a father of one of the people that was injured. We're not clear on that relationship, no matter how well prepared the speech was, because it was a prepared speech. That was obvious. Where's the proof? I just asked that same question. Can an affidavit be given that there is no bias, no conflict of interest, and no interest in the outcome of this case? There's no proof if you hold the full judicial power of the state, or is it the military power?
Mr. Brooks, I've given you about 50 minutes to make your various arguments. You've now repeated yourself a number of times, so I'm going to turn to the state to see if they have any response.
I've never heard of someone intentionally trying to hurt someone while attempting to blow their horn. While attempting to alert people of their presence. Which brings me to more information that I believe that you should have been privy to. And I'm sure that the prosecution will beg to differ. But the fact of the matter is, vehicle in question, make a model of 2010 Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection, misstatement of the facts, facts not in evidence.
Was in fact,
For argument, Your Honor.
Sustained.
was in fact recalled. Was in fact a class action lawsuit against Ford
Objection.
for those
facts not
model
in evidence,
for
Your
those
Honor.
model vehicles.
Sustained. The juror will disregard.
Information that you should have been privy to, that you weren't allowed to be privy to. Why? I don't know. That information, malfunctioning throttle bodies,
Mr. Brooks, move out.
is the information that you should have been privy to. Vehicles that malfunction and accelerate not being able to be stopped.
Objection, that is.
It's information, it's information.
Objection. Hold on. Go ahead.
Move to strike statements by.
Sorry
Mr.
for the
Brooks.
interruption.
Facts not in evidence, Your Honor, and it's complete misstatement.
Sustained.
How's it a misstatement when I have the information?
Mr. Brooks, move out.
This is information that I feel like you needed to know. You should have known. Information that was taken away from you. Why? To prove a case? Information that you definitely should have been privy to. DA says the defendant has utter disregard for human life. Utter disregard for human life. Not realizing that they're talking about someone that has children. Talking about someone that watched their children come out of the womb, born into this world, cut their umbilical cord, held them before their mom even did it. Moments that I'll never forget. And yet they say disregard, utter disregard for human life. They made reference to a rage, as if they were, or if this particular DA was right there, standing right there, as if this DA is a psychiatrist. I say to myself, what rage? What do you mean rage? How can you characterize that? How can you have the audacity to diagnose what someone's brain is, where it's at, what it's thinking, why it thinks the way it does? DA makes references to blocks of no one being injured, but then says it's intentional. You add that up with the supposed rage, the supposed intent to harm and kill. and it doesn't kick in until well within blocks. And maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger, then why weren't people immediately harmed? Why would someone with intent to kill and rage try to alert people of their presence, repeatedly hump their horn? You heard a detective, if you recall, testify that the vehicle that he observed was not only honking his horn, but was not speeding. So where does this rage kick in? Where does this insatiable intent to kill kick in? I speak as someone who's known someone for years. Which brings me back to the vehicle. What if the vehicle couldn't stop because of the malfunction?
Objection, fact, not evidence.
What if the driver of the vehicle was unable to stop the vehicle? Because of that fact, what if the driver may have panicked? Does that make the driver a crazed, or not crazed, a rage? Does that make the driver in a rage and intent on killing people? DA played Exhibit 17. You don't see anyone struck in that vehicle. On that exhibit, you don't see anyone struck. Was someone who had this intent to kill, this rage, as she says. If that was their intent, wouldn't they have taken the opportunity to hit as many people as they could? Target people, mow down people. Reference was made to this vehicle, the damage. Says this was all caused by bodies, but then later turns around and says hits barricades and other objects. You've heard testimony about hearing loud crashes and things of that nature, but the DA wants you to believe that this all came from people. Evidence doesn't support that. So I go back to trying to wrap my head around everything that's happened in the last year. Praying for those families, praying for the people that tragically lost their life, because that should not be lost either. The fact that there was lives lost, and all the emphasis has been put on the alleged defendant. And the people have been disregarded. Makes me wonder, does the DA even care about those people? There's been prayers going up every day. There's been suffering on both sides. There's been threats, hate mail. Because of the narratives that's been put out there. The misconceptions that have been put out there. The lies that have been put out there. Lies that have caused my children not to be able to go to school. To be bullied. For my mother to have to leave her home and stay at a hotel because she's afraid for her safety. Because she gets hate mail shoved through her mailbox. My nieces and nephews to fear for their safety. What's been equally hard is not only having to answer the questions from my daughter who was 7 at the time, my baby girl who was 7 at the time, is now 8. Attempting to answer her questions that she's asking and still continue to shield her from what she sees, what she hears. Having a newborn son that I haven't even been able to meet. I haven't been able to hold, touch, kiss. Having to navigate everything that comes with this whole situation. While still attempting to wrap my head around it. I can't honestly say how many times I've sat in my cell, especially during lights out, alone, where it's just you. And just been praying and asking myself, how could this happen? Not just for the people, but for everybody involved, the community too. How could this happen? How? The hardest questions you can ask is those that don't have an answer. No matter how much thinking you do, no matter how much you try to look at it from different perspectives and listen to other outside perspectives and listen to people that you trust and that you love, still coming up with nothing. But to think for 1 second, one question I never had to ask was if this was intentional. That's something that never even As a matter of fact, it never even crossed my mind to even attempt to ask myself that, because I know it wasn't. And I know sometimes during this trial probably doesn't show. Maybe hard to believe. But trust me when I say no one outside of the families that had to go through this, no one's heart is more in pieces than mine. So again, I go back to all these exhibits. Go back to everything that's been shown, everything that's been testified to. Everything you've heard during this whole process, this trial. And again, I say the same thing that I said earlier. The same thing I said in opening statements. I'm not reading from any paper, any books. Everything you've heard in opening statements, everything you're hearing now is from right here. Everything. You have the decision. You and you alone. All of you. You have the decision. I'm sure you've taken a lot of notes during this process. Some days are longer than others. A lot of movement in and out of the courtroom for various reasons. Remember the power that you have. Don't for 1 second let it be taken away from you. I can never understand the position of sitting on the jury in something of this magnitude. So I'm sure there's a lot of pressure. I pray that the right decision is made. The right decision. It's almost like that message, well not message, but that writing. We're in our vehicles and we said things are closer than they appear. But it's also another way of saying sometimes things aren't as they appear. I can't speak for anyone else, but me, myself, I believe in Jesus Christ. That's how I was raised. That's what I believe in. None of us are perfect. But I try every day to make sure that I acknowledge him. That's why every time I step in this courtroom, I have my Bible with me everywhere I go. I even read it on breaks, recesses. This is not something that started at the beginning of this incident. This is something that has been instilled in me since I came out of the womb. This is how my family lives their life. This is how we was raised. For whatever mistakes that I myself have made in my life, I've made peace with God. Made peace. I'm happy to say that my conscience is clear. And because I believe, I trust him with my life. Nobody will never know why it was his will for this to happen. A lot of lives were changed that day, mine included. God's way is not our own. And no matter how much sometimes we want to question, we have to have faith. Look inside yourself. Look inside yourself and make the right decision. Look inside your heart. was right. Do what's right. Don't let the smoke and mirrors take away your power. Don't let the theatrics take away your power. Each and every one of you has a decision. What's right? Make the right decision. It's hard to think about my younger kids getting older and at some point having to explain everything to them. Kids don't stay kids forever. And nowadays, kids is frankly a lot smarter than we was kids. I'll tell you that much. I got a letter the other day. My youngest daughter. And she's still learning cursive right now, so she's the best writer when it comes to cursive. She'd rather print. She said, Dad, and this is from the letter. She said, Dad, are people saying all these mean things about you? I haven't read the rest of that letter yet. The rest of that sentence said, that's not the dad I know. Throughout this year, I've been called a lot of things. And to be fair, I am a lot of things. A murderer is not one of them. Never has been, never will be.
those my statements. Just want to say, open your hearts. Go inside yourself when making this decision. Have no fear. Pray and do what you know is right. You know is right. Think about everything you've heard. Think about everything you haven't been privileged to hear. Think about the whole entire picture. And above everything, whatever you decide, make sure you yourself can live with it. Make sure you can live with it. That's the magnitude of the power that you have. Just like this tissue is in my hand, this is everything. You have everything. Be at peace with what you decide. Have no regrets. Don't let this decision weigh on you after it's over. Hopefully we got a lot of living ahead of us. Lord willing. Don't look back and kick yourself in the behind. Spent about 3 weeks with you. It took a lot of courage and a lot of guts to pause your life for this. To put important things on hold. To basically stop your life.
commended for being able to sit up here with this amount of pressure. I want you guys to know that's not lost on me. I'm sure it's a lot. And you all should be commended because it took courage to do this. I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now. And you guys had the guts to do it. Thank you for that. Thank you for taking pretty much a month and setting it to the side for this. I know it's probably not proper, but you guys deserve a round of applause if you could get one. Thank you guys sincerely. And I know, and I have faith and I trust that you guys know what's right. Ladies and gentlemen, I don't think it's fair to just say guys. I believe in your heart you know what's right. Thank you.
Thank you, sir. Before I give the state an opportunity to present rebuttal, please stand for a minute. So please stand. All right, have a seat, please. And Attorney Apper, I did time both closings. You have 13:28 left.